All right, good morning. I've got a few announcements this morning. This meeting was properly noticed by having the agendas placed on the board's website on Monday, July 14th, 2014. At this time, I'm the only one that has been reappointed by the governor's office to the board. My term will expire June 30, 2017. Mrs. Brundage and Mr. Roberts will not be with us today as they had unavoidable conflicts in their schedules. And do want to remind all the board members to speak up, speak into the microphones. If the red light is on, then is not on, then you're not being recorded. And then I'd like to introduce Josh Cannon over here, our newest employee. We had 126 applications for this position, the one vacated by Christy Burton as complaint coordinator. They offered interviews to 12 individuals and chose Josh as the best candidate. So welcome, Josh. And then I'd like to ask for a roll call of all present, please, starting with Mr. Alexander.
Alexander.
Stephen Eldridge.
Casey Stewart.
Trey Watkins.
Bill Bluffus.
Troy Brewer.
Don Royston.
Charlene Spiceland.
Henry Hoss.
Thank you. Everybody should have a copy of the minutes to the meeting on May 2nd, 2014. Actually, you know what, Mark? I guess I can't do this right now, can I? Because it's on the schedule at 9.
If you will wait just a minute.
Okay.
We actually have a presentation here, Mr. Watkins,
Oh.
for you, which is why I didn't put it on the announcements. This is gavel. We've had it engraved with William H. Watkins III with your terms of service, and the base says Tennessee State Board of Accountancy. Congratulations.
Appreciate it. Thank you.
You've done an outstanding job. That's where your gavel went.
That's right. Thank
You may use it during the rest of the meeting and then take it home with you.
I appreciate that. Maybe I doubt my wife will recognize it. That's right. Okay, I guess we'll go straight into the, I certainly appreciate it to everybody here. We have a great group of individuals on this board, and it makes it a pleasure to serve with everyone here. The fact that everybody's engaged and participates, I think that's important, and everyone here does a valuable service to our profession, so thank all of you as well. I guess, Mark, let's go ahead and do the Executive Director's report.
Thank you, Mr. Chairman. You all have a copy of this in front of you. There are just a couple of things I'd like to highlight. Henry Hoss and Troy Brewer and I did attend the NASBA Eastern Regional Meeting held in Louisville this year, and I've asked Henry to make a few comments about that and let you have his opinion on how things went and what he learned. And Troy, if you'd like to chime in at any time, feel free to do so.
Well, thank you, Mark. This was a kind of a long 3-day meeting, Wednesday, Thursday, and Friday. We were there for, Troy and I were there on Wednesday for kind of a training session for new board members that they had, and then the regular meeting was held on Thursday and Friday. It was very interesting from my perspective to develop a little bit of understanding of what other states are having to deal with. I think all boards have some kind of a governmental authority, such as a legislature like we do, that dictates what our actual accountancy law is to be. And every state has something like that that's a little bit different. We were at a committee, or at I think it was Southern States regional meeting, and we were talking about the state requirements for peer review. And one state, Florida, spoke up and mentioned that their peer review did not include compilations and reviews. And their explanation of that was that there was a state senator that sister was a CPA, and she didn't want to have to deal with peer review, and she didn't do any audits. And so he was able to get compilations reviews excluded from their peer review program. And you have little issues like that with most states. around the country, not necessarily just in peer review, but doing a lot of different things, and which brings about a lot of differences between the different boards. And I found that all to be very, very, very interesting.
Or you want to add anything?
I guess the one change they had, I thought it was interesting that they had the CPEs were doing the 15-minute increments, which I thought that was something new from the year before, and I don't know how that's going to work here or get here. But I ran that through my mind. If you're doing that every 15 minutes, if you did, you could do a course at you'll probably do them back to back to back, I guess. But when you think about how much time that is, but I thought it was interesting when I left and came back home. I noticed that the hospitals were doing that. I talked to a few folks that they may have CPEs, but they have hours. Physicians, some other professions, they also have looked at the 15-minute spot, which I thought was interesting.
And I think that nano learning, as they call it, is something that we're going to have to address in the not-too-distant future, because Ohio has already adopted legislation to allow 10-minute increments for CPE, and Maryland is considering that legislation. If they're allowing it, then how are we going to audit them should they come into our state under a provision where they are an older CPA who doesn't have 150 hours, and we have to go back and verify their 80 hours of CPE? Are we going to allow that? Under our law and rules, I'm not sure that we could. So it's something that we're going to need to be keeping abreast of, and something that we're going to need to be aware of as it goes forward. Mr. Royston, you look confused.
They add up to the same number of 80 hours. Do we care whether they got it in 50-minute increments or 5-10-minute increments? Doesn't it add up to the same thing?
Our rules require 50-minute increments.
The way it's spelled out?
I would also point out to you that NASBA's annual meeting is scheduled for November 2nd through 5th in Washington, D.C. If you're going to be able to attend that meeting, I'd appreciate you letting me know that. I know Dr. Spiceland wants to go. Any of the rest of you that want to go, please let me know so I can get the travel authorizations approved. I would like for you to attend, if at all possible. I think Henry and Troy found the regional meeting to be very beneficial. I think the annual meeting is interesting. November 2nd through the 5th. There's also a listing of proposed future meeting dates there for you to put on your calendars through January of 2016. If you would look at those and get those slotted, that would be an excellent idea. I will point out to you that Mr. Giannini, the Assistant Commissioner for Regulatory Boards, has been promoted. He is now the Deputy Commissioner for the department. He will be overseeing reg boards. My understanding is they are not pursuing replacing him immediately. He's going to be doing both jobs for a while, but I'm assuming that at some point we will have another assistant commissioner appointed. If you see Mr. Giannini or you know him, send him a note of congratulations. This is a good step for him professionally, and I think he'll do a good job for us. Mr. Myshak, who was our assistant commissioner and who met with you all at the retreat, took a job as a firefighter. He found his calling, so to speak, and took the training and got a job in Rutherford County as a second shift supervisor, and has gone to do that. So he's all gung-ho. I do want to mention some legislation that we're going to have to deal with here, and Chris will address this a little bit later. I just want to make you aware of it. The two that I'm really concerned about, or that we're going to need to address, are Public Chapter 881, which requires the board to create an apprenticeship program, which includes at a minimum the subjects of apprenticeship training, supervisory standards, occupational instruction, wages and benefits, licensure, and the role of the Division of the Regulatory Board in implementing and maintaining the program. We think that our work experience requirement will satisfy this particular need, but it is something we're going to have to outline and present to the department for approval, and then you all will have to approve it at the October board meeting because the deadline is December 31st. So we're hoping to have that done for you, and I'll get it out to you a couple of weeks before the board meeting in case there are any questions that you may have about it, but it's something we're going to have to do. It's going to be a requirement. And Chris will cover that a little bit later. Public Chapter 763 addresses professional privilege tax. This law says that the Commissioner of Revenue will provide to the boards every month those who are 90 days or more delinquent in payment of the professional privilege tax. If a licensee is on that list, we are not to renew their license. We have additional punishment that we take and as a result of the recent rule changes, but this is simply an option that we can't renew their license. Now, the problem is the current system that we have for renewal allows people who are delinquent to renew online automatically. The IS department is working on putting on some type of manual modifier so that we're going to have to go in and manually indicate which licensees are delinquent in payment of professional privilege tax and put that modifier in there so that they cannot renew. The system will take their money, but they won't have a license. So I want you to be aware of that, know that it's coming, and we'll keep you updated with the details on how that's going to operate.
Mark, when you go in to do it, is there a question that asks, have you paid your privilege tax?
No, ma'am.
I didn't think there was.
That's not a requirement for licensure.
Could we add it as a question just to, even though we couldn't read?
Wouldn't that make it easier to deal with? I mean, if somebody lies about paying their privilege tax, then obviously if it's a complaint before the board, would that not just be something simple for Chris? I would think from a legal standpoint that it's just one more reason to.
I would say that making a false statement about having paid professional privilege tax be classified as a discreditable act, separate and apart from the non-payment itself.
Right.
So if there's such a question.
I mean, aren't people more apt to think when they see that question, you know what, I better do this?
Maybe they do it before they go online and pay their money and then don't have a license.
I'll investigate that, Dr. Spice, and I'll get back to you. The last item on my report concerns staggered renewals. As you all know right now, we renew licenses, odd numbers renew in odd-numbered years on December 31st, even numbers renew in even-numbered years on December 31st. The new system is more automated and will actually spit out a license based on the month that you received your license. If we continue to maintain a December 31st renewal, that's going to require manual entry at some point by staff. If we authorize staggered renewals, then there's no manual entry required and it simply kicks into the system. And say if Mr. Stewart applies for a license in March of 2014, it will automatically be due for renewal March 31st of 2016.
Quick question about that on your CPE
Yes.
requirements. Is that going to present some problems when initiated on, I mean, that would then become your audit period presumably, or would we keep that on a calendar year?
So that would be your audit period.
Okay.
Because your CPE is tied to your renewal period, and it simply would be a matter of having a rolling CPE audit.
Would you take Mr. Stewart's back to, I mean, would it just be on the date that he applied a couple of years ago for his license?
No, the ones that are in the system now would
Would
remain
stay.
December 31st
Okay.
renewals.
It would
It's just
only be the new.
Only
okay.
the future ones. Yes. Yes, Mr. Royston.
Mark, I think we need to give that serious thought because you're talking about changing, you go back to the firm levels where they track CPEs, and then the licenses, they do it once a year, they've got a checklist instead of having, say they've got 50 CPAs where they're going to have to do that every month. Once a year, your CPE is closed out, everything's on a calendar year. I would not recommend personally even
agree.
considering changing it. I think we're creating a nightmare.
Okay.
I think the practitioner level is going to have a difficult time with that.
Okay. Well, it's something that I'm bringing up because that's the way the new system is designed. Now, we can request that this manual entry be made so that we continue to renew it December 31st, if that's how you all wish to pursue it.
Is there not a way to trick the system into thinking that they applied on December 31st? And if you have a date that you're setting in there, if it's March 31st for Mr. Stewart, for example, could you not, I'm just thinking, is there a workaround? Can you put in a December 31 date I don't know if you can track 2 dates. I mean, it may create a different problem, but
I don't think so, Mr. Watkins. What,
to
because
keep it
picks up-
automated.
It keeps up the date that it's initially approved.
Okay,
And then it goes 2 years from that date
okay.
to the end of the month.
So is just question, the purpose behind this is it to try and lessen the burden of everyone having their licenses due at the same time? Or is this just a system?
It's a system rewrite, if you will. I mean, that's the way all the other boards are operating right now. We're the oddballs.
Right.
All the other reg boards are enrolling to this staggered renewal system. When I say all the other reg boards, I mean all the ones in Tennessee.
Oh, okay.
And
is
many
that
of the other states also have a staggered renewal system.
Due
but-
to the burden of everyone having their license due at the same time?
At the same time, yes. But on the other hand, the core system is supposed to be more efficient, and it could be that having all the CPAs trying to renew on December 31st will not be a problem for that system as it has been for the one that we have currently. I will go back to the implementers and see if there's a workaround. They've assured me that it will require a manual entry on our point, but we'll see what answers I get. Anything else on that? I think that concludes my report, Mr. Chairman.
Thank you, Mr. Crocker. I guess we're going to have to hold off on everything until 9. I don't believe. Well, it's on here for 9, so I'm not sure I can do it right now. So, if y'all want to take a break here, we'll reconvene at 9.
Yeah.
All right, good morning. I've got a few announcements this morning. This meeting was properly noticed by having the agendas placed on the board's website on Monday, July 14th, 2014. At this time, I'm the only one that has been reappointed by the Governor's Office to the board. My term will expire June 30, 2017. Mrs. Brundage and Mr. Roberts will not be with us today as they had unavoidable conflicts in their schedules. And do want to remind all the board members to speak up, speak into the microphones. If the red light is on, then is not on, then you're not being recorded. And then I'd like to introduce Josh Cannon over here, our newest employee. We had 126 applications for this position, the one vacated by Christy Burton as complaint coordinator. They offered interviews to 12 individuals and chose Josh as the best candidate. So welcome, Josh. And then I'd like to ask for a roll call of all present, please, starting with Mr. Alexander.
Alexander?
Stephen Eldridge.
Casey Stewart,
Trey Watkins.
Bill Blofus,
Troy Brewer.
Don Royston.
Charlene Spiceland?
Henry Hoss.
Thank you. Everybody should have a copy of the minutes to the meeting on May 2nd, 2014. Actually, you know what, Mark? I guess I can't do this right now, can I? Because it's on the schedule at 9.
If you will wait just a minute.
Okay.
We actually have a presentation here, Mr. Watkins,
Oh.
for you, which is why I didn't put it on the announcements. This is gavel. We've had it engraved with William H. Watkins III with your terms of service, and the base says Tennessee State Board of Accountancy. Congratulations.
Appreciate it. Thank you.
You've done an outstanding job. That's where your gavel went.
That's right. Thank
You may use it during the rest of the meeting and then take it home with you.
I appreciate
okay?
that. Maybe my. I doubt my wife will recognize it. That's right. Okay, I guess we'll go straight into the, I certainly appreciate it to everybody here. We have a great group of individuals on this board, and it makes it a pleasure to serve with everyone here. And the fact that everybody's engaged and participates, I think that's important, and everyone here does a valuable service to our profession, so thank all of you as well. I guess, Mark, let's go ahead and do the executive director's report.
Thank you, Mr. Chairman. You all have a copy of this in front of you. There are just a couple of things I'd like to highlight. Henry Haas and Troy Brewer and I did attend the NASBA Eastern Regional Meeting held in Louisville this year, and I've asked Henry to make a few comments about that and let you have his opinion on how things went and what he learned. And Troy, if you'd like to chime in at any time, feel free to do so.
Well, thank you, Mark. This was a kind of a long 3-day meeting, Wednesday, Thursday, and Friday. We were there for, Troy and I, they were there on Wednesday for kind of a training session for new board members that they had, and then the regular meeting was held on Thursday and Friday. It was very interesting from my perspective to develop a little bit of understanding of what other states are having to deal with. I think all boards have some kind of a governmental authority, such as a legislature like we do, that dictates what our actual accountancy law is to be. And every state has something like that that's a little bit different. We were at a committee, or at I think it was Southern States regional meeting, and we were talking about the state requirements for peer review. And one state, Florida, spoke up and mentioned that their peer review did not include compilations and reviews. And their explanation of that was that there was a state senator that sister was a CPA, and she didn't want to have to deal with peer review, and she didn't do any audits. And so he was able to get compilations reviews excluded from their peer review program. And you have little issues like that with most states around the country, not necessarily just in peer review, but doing a lot of different things, and which brings about a lot of differences between the different boards. And I found that all to be very, very, very interesting.
Or you want to add anything?
I guess the one change they had, I thought it was interesting that they had the CPEs were doing the 15-minute increments, which I thought was that was something new from the year before, and I don't know how that's going to work here or get here. But I ran that through my mind. If you're doing that every 15 minutes, if you did, you could do a course at you'll probably do them back to back to back, I guess. But when you think about how much time that is, but I thought it was interesting when I left and came back home. I noticed that the hospitals were doing that. I talked to a few folks that they may have CPEs, but they have hours, physicians, some other professions. They also have looked at the 15-minute spot, which I thought was interesting.
And I think that nano learning, as they call it, is something that we're going to have to address in the not-too-distant future, because Ohio has already adopted legislation to allow 10-minute increments for CPE, and Maryland is considering that legislation. If they're allowing it, then how are we going to audit them should they come into our state under a provision where they are an older CPA who doesn't have 150 hours, and we have to go back and verify their 80 hours of CPE? Are we going to allow that? Under our law and rules, I'm not sure that we could. So it's something that we're going to need to be keeping abreast of, and something that we're going to need to be aware of as it goes forward. Mr. Royston, you look confused.
They add up to the same number, about 80 hours. Do we care whether they got it in 50-minute increments or 5, 10-minute increments? Doesn't it add up to the same thing?
Our rules require 50-minute increments.
The way it's spelled out?
I would also point out to you that NASBA's annual meeting is scheduled for November 2nd through 5th in Washington, D.C. If you're going to be able to attend that meeting, I'd appreciate you letting me know that. I know Dr. Spiceland wants to go. Any of the rest of you that want to go, please let me know so I can get the travel authorizations approved. I would like for you to attend, if at all possible. I think Henry and Troy found the regional meeting to be very beneficial. I think the annual meeting is interesting. November 2nd through the 5th. There's also a listing of proposed future meeting dates there for you to put on your calendars through January of 2016. If you would look at those and get those slotted, that would be an excellent idea. I will point out to you that Mr. Giannini, the Assistant Commissioner for Regulatory Boards, has been promoted. He is now the Deputy Commissioner for the department. He will be overseeing reg boards. My understanding is they are not pursuing replacing him immediately. He's going to be doing both jobs for a while, but I'm assuming that at some point we will have another Assistant Commissioner appointed. If you see Mr. Giannini or you know him, send him a note of congratulations. This is a good step for him professionally. And I think he'll do a good job for us. Mr. Myshak, who was our Assistant Commissioner and who met with you all at the retreat, took a job as a firefighter. He found his calling, so to speak, and took the training and got a job in Rutherford County as a second shift supervisor and has gone to do that. So he's all gung-ho. I do want to mention some legislation that we're going to have to deal with here, and Chris will address this a little bit later. I just want to make you aware of it. The two that I'm really concerned about or that we're going to need to address are Public Chapter 881, which requires the board to create an apprenticeship program, which includes at a minimum the subjects of apprenticeship training, supervisory standards, occupational instruction, wages and benefits, licensure, and the role of the Division of the Regulatory Board in implementing and maintaining the program. We think that our work experience requirement will satisfy this particular need, but it is something we're going to have to outline and present to the department for approval, and then you all will have to approve it at the October board meeting because the deadline is December 31st. So we're hoping to have that done for you, and I'll get it out to you a couple of weeks before the board meeting in case there are any questions that you may have about it. But it's something we're going to have to do. It's going to be a requirement. And Chris will cover that a little bit later. Public Chapter 763 addresses professional privilege tax. This law says that the Commissioner of Revenue will provide to the boards every month those who are 90 days or more delinquent in payment of the professional privilege tax. If a licensee is on that list, we are not to renew their license. We have additional punishment that we take and as a result of the recent rule changes, but this is simply an option that we can't renew their license. Now, the problem is the current system that we have for renewal allows people who are delinquent to renew online automatically. The IS department is working on putting on some type of manual modifier so that we're going to have to go in and manually indicate which licensees are delinquent in payment of professional privilege tax and put that modifier in there so that they cannot renew. The system will take their money, but they won't have a license. So I want you to be aware of that, know that it's coming, and we'll keep you updated with the details on how that's going to operate.
Mark, when you go in to do it, is there a question that asks, have you paid your privilege tax?
No, ma'am.
I didn't think there was.
That's not a requirement for licensure.
Could we add it as a question just to, even though we couldn't read
Wouldn't
it?
that make it easier to deal with? I mean, if somebody lies about paying their privilege tax, then obviously if it's a complaint before the board, would that not just be something simple for Chris? I would think from a legal standpoint that it's just one more reason to.
I would say that making a false statement about having paid professional privilege tax be classified as a discreditable act, separate and apart from the non-payment itself.
Right.
So if there's such a question.
I mean, aren't people more apt to think when they see that question, you know what, I better do this?
Maybe they do it before they go online and pay their money and then don't have a license.
I'll investigate that, Dr. Spice, and I'll get back to you. The last item on my report concerns staggered renewals. As you all know right now, we renew licenses, odd numbers renew in odd-numbered years on December 31st, even numbers renew in even-numbered years on December 31st. The new system is more automated and will actually spit out a license based on the month that you received your license. If we continue to maintain a December 31st renewal, that's going to require a manual entry at some point by staff. If we authorize staggered renewals, then there's no manual entry required, and it simply kicks into the system. And say if Mr. Stewart applies for a license in March of 2014, it will automatically be due for renewal March 31st of 2016.
Quick question about that on your CPE
Yes.
requirements. Is that going to present some problems when initiated on, I mean, that would then become your audit period presumably, or would we keep that on a calendar year?
So that would be your audit period.
Okay.
Because your CPE is tied to your renewal period, and it simply would be a matter of having a rolling CPE audit. as
Would you
opposed-
take Mr. Stewart's back to, I mean, would it just be on the date that he applied a couple of years ago for his license?
No, the ones that are in the system now would
Would
remain
stay.
December 31st
Okay.
renewals.
It would
It's just
only be the new.
Only
okay.
the future ones. Yes. Yes, Mr. Royston.
Mark, I think we need to give that serious thought, because you're talking about changing, you go back to the firm levels where they track CPEs, and then the licenses, they do it once a year, they've got a checklist, instead of having, say they've got 50 CPAs, where they're going to have to do that every month. Once a year, your CPE is closed out, everything's on a calendar year. I would not recommend personally even
agree.
considering changing it. I think we're creating a nightmare.
Okay.
I think the practitioner level is going to have a difficult time with that.
Okay. Well, it's something that I'm bringing up because that's the way the new system is designed. Now, we can request that this manual entry be made so that we continue to renew it December 31st, if that's how you all wish to pursue it.
Is there not a way to trick the system into thinking that they applied on December 31st? And if you have a date that you're setting in there, if it's March 31st for Mr. Stewart, for example, could you not, I'm just thinking, is there a workaround? Can you put in a December 31 date? I don't know if you can track two dates. I mean, it may create a different problem, but
I don't think so, Mr. Watkins.
to
Because
keep it
picks up-
automated.
It keeps up the date that it's initially approved.
Okay,
And then it goes 2 years from that date
okay.
to the end of the month.
So is just question, the purpose behind this is it to try and lessen the burden of everyone having their licenses due at the same time? Or is this just a system?
It's a system rewrite, if you will. I mean, that's the way all the other boards are operating right now. We're the oddballs.
Right.
All the other reg boards are enrolling to this staggered renewal system. When I say all the other reg boards, I mean all the ones in Tennessee.
Oh, okay.
And
is
many
that
of the other states also have a staggered renewal system
Due to
but-
the burden of everyone having their license due at the same time?
at the same time. Yes. But on the other hand, the core system is supposed to be more efficient, and it could be that having all the CPAs trying to renew on December 31st will not be a problem for that system as it has been for the one that we have currently. I will go back to the implementers and see if there's a workaround. They've assured me that it will require a manual entry on our point, but we'll see what answers I get. Anything else on that? I think that concludes my report, Mr. Chairman.
Thank you, Mr. Crocker. I guess we're going to have to hold off on everything until 9. I don't believe. Well, it's on here for 9, so I'm not sure I can do it right now. So, if y'all want to take a break here, we'll reconvene at 9.
Yeah.
Guys, in your,
Good morning, how are y'all? No, you're fine.
if everybody will look in their iPad, you should have the minutes from the May meeting. If you would, please review those quickly, and then we'll entertain a motion to accept those minutes.
I'd make a motion, sir, that we approve them as presented.
Okay, I have a motion on the
I'll
floor.
second
Do I have
that
a
motion.
second? Okay, Mr. Eldridge seconded. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Okay. Ayes have it. The minutes pass. All right, Chris, do you want to go ahead and get started?
Thank you, Mr. Chairman. You got 3 potential formal hearings on the docket today. One, the respondent has recently retained counsel, so we'll be doing an agreed order of continuance for that one. And then we will get started on the other 2 right after that. So with that, Judge Collier?
Thank you, Mr. Whitaker. Did you want me to, you can just give me the agreed order when we're finished.
That'd be fine.
That's fine. All right. And that's, which docket, which case was that, Quan?
That would be Shannon Kwan.
All right. And that's going to be continued, board members, to your October meeting, which we will find you a judge. Apparently, your staff told us a different date than the date y'all are going to be here, but they have it on our list of things we need to fill. So between now and October, we'll find someone. It may be me. It may be someone else. That happens this late in the year because we get everybody's calendars in September for the next year. So it's been nearly a year since we got that date. So as the year goes by, some people change things. And Chris, if you'll just remind your people to, next time these people change something, to tell us.
Thank you, Your Honor. Director Crocker and I have already spoken about that. It just seemed like there was a breakdown somewhere, and looks like the website, board's website got updated, which is important for notice purposes.
Exactly.
But, we don't know where the notice to you guys should have come from, but we'll be in charge of that from now on.
Excellent. Thank you. All right. Well, the first case we've got this morning is Jeanette Carlson Whale, which is W-A-H-L-E.
Your Honor, the pronunciation would be Carlson Wall.
Carson Wall.
Yes, ma'am.
Okay. And is there anyone here for Carson Wall? All right. That notice of hearing was filed in our office on June the 10th of 2014. I think you all have copies of that on your iPads. If y'all want to pull that up, please. And as you're reviewing that, I'll do a little bit of introductory information. I know I've met most of you, but I think I do recognize a few new faces. I'm Judge Mary Collier. I'm one of the administrative judges with the Central Panel, and I'm here to preside with you all this morning in the 2 hearings you have set. Today is, July the 25th, and this is the Tennessee State Board of Accountancy. And the docket number for the Jeanette Carlson Wall case is 12.19-126286A. There are 3 documents that I have in my file. That's the original notice of charges you all are looking at, the scheduling order that I sent out on June the 20th of 2014, and the state's witness and exhibit list that was filed on July 17th of 2014. Do you have proof of service for the respondent, Mr. Whitaker?
Your Honor, we'll have a motion for default. We have many attempts at service, and we'd like to start by introducing proof of that into the record, and then we'll have a motion at the conclusion of the introduction of attempted proof of service. State calls Donald Mills.
Got a name tag here, but apparently that's not him.
We've appropriated Mr. Mills' chair for litigation purposes.
Mr. Mills, please raise your right hand. Do you swear or affirm that the testimony you're about to present will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Morning, Mr. Mills. Can you please state your name and position for the record, please?
My name is Donald A. Mills. I'm an investigator for the board.
And how long have you been an investigator with the Tennessee State Board of Accountancy?
Since January 1st, 2008.
And prior to your testimony today, have you reviewed Ms. Carlson Wall's licensing and complaint files?
Yes.
And are you the board investigator assigned to both complaints against Ms. Carlson Wall, which are the subject of today's hearing?
Yes.
Okay, I'd like to, at this time, show you a document and ask you to identify it for the record, please.
Yes, these are the emails, the email correspondence I had with Ms. Carson Wall. and attachments.
Okay, and are these documents kept in the regular course of business for the Accountancy Board?
Yes.
Are they maintained in Ms. Carlson Wall's complaint file and in your investigative report in this matter?
Correct.
Your Honor, at this time, I request that this set of documents, email exchange between Mr. Mills and Ms. Carlson Wall from October 2013 be entered as Collective Exhibit 1.
You'll pass those over, please? No, to me?
Your Honor, do we need to wait to publish to the board until?
Well, I'll read it, yes.
Yes, thank you.
Members of the board, the documents that Mr. Mills has just identified, email communications between him and the respondent in this matter will be marked and entered in evidence as Exhibit Number 1, and at this time I'll let the state pass you all copies of that exhibit.
Mr. Mills, is d.a.mills@tn.gov your official email address from which you conduct the email portion of your duties as board investigator?
That's correct.
And directing your attention to the first page of this exhibit, can you please read for the record the email address at which you attempted to contact Ms. Carlson Wall?
Yes, it was accountingdirect@yahoo.com.
Okay. And on what date did you send the first email to Ms. Carlson Wall at that email address?
October the 16th, 2013.
What was the purpose of this email?
I basically attached some documents to the email that I stated that required her attention. Wanted to give her an opportunity to surrender her Tennessee license, and that we would take care of the matter at the next board meeting, which I think was the following Friday. I wanted to give her time to prepare an affidavit and submit it to me.
Okay. And did you receive a response to the email that you sent to Ms. Carlson Wall at that email address on October 16th of 2013?
Yes, I did.
And on what date did you receive the response to your email?
I received a response the next day, October the 17th.
And what did Ms. Carlson Wall's response say?
Stated that she did not wish to surrender her license.
Okay. And do you believe that the response you received was from Ms. Carlson Wall?
Yes.
And why do you believe that?
Well, for one thing, she spelled her name correctly. Geannette. So I assumed having the correct spelling meant that was from her.
And did you send a follow-up response email to Ms. Carlson Wall's email of October 17th?
Yes, I did.
And when did you send that follow-up?
On the 17th, the same day.
Okay. And did Ms. Carlson Wall also respond to that follow-up email of October 17th?
She did.
And on what date did she respond to your October 17th email?
Later the same day, October 17th.
And what did Ms. Carlson Wall's October 17th second email say?
She thanked me. She said that she believed once all the facts in the case were evident, that it would be dismissed.
And so at the conclusion of your email exchange with Ms. Carlson Wall on October 16th and 17th of 2013, do you believe that Ms. Carlson Wall had received notice that there were complaints pending against her, which ultimately became the subject of today's formal hearing?
Yes.
And do you believe that Ms. Carlson Wall understood the nature of the complaints against her?
Yes.
And after your email exchange of October 16th and 17th, 2013 with Ms. Carlson-Wall, did you ever hear from Ms. Carlson-Wall again relative to those complaints?
No, I did not.
Thank you, Mr. Mills. I have no further questions.
Members of the board, do you all have any questions for Mr. Mills? Thank you, Mr. Mills.
Your Honor, the state would call Jenica Smith.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you.
Morning, Ms. Smith. Can you please state your full name and position for the record, please?
Jenica Smith, I'm a paralegal for Commerce and Insurance Regulatory Boards.
How long have you been a paralegal with the Department of Commerce and Insurance?
February 2014.
And are you the lead paralegal assigned to work on this matter for the state in preparation for today's formal hearing?
Yes.
And prior to your testimony today, have you reviewed Ms. Carlson-Wall's complaint files prior to your testimony?
Yes.
And based on your review of the file, what date was the notice of hearing and charges filed in this matter?
In 2014.
And by what methods was service attempted on the respondent for the notice of hearing and charges in this matter?
Did certified mail and email.
And did you also attempt to contact the respondent by phone to advise her of the notice of hearing and charges and today's formal hearing?
Yes.
And how did you decide where and how to attempt to notify the respondent of today's hearing?
I performed a Westlaw Clear search.
Can you please explain briefly for the record what a clear search is?
It's a search that is a paid service from Westlaw, and it compilates all public records for an individual.
And how does a clear search ensure that the subject of the search is actually the right person in case there's more than one person with the same name and something like that?
In this case, I had the respondent's social security number.
And is Ms. Carlson-Wall, is her social security number maintained in the regulatory board system for the division?
Yes, it was in the database.
Does the social security number in the database match the social that came out on the clear report that you ran?
Yes.
On what date did you run the clear search for Ms. Carlson-Wall?
June 9th, 2014.
Okay, and can you please identify for the record the addresses which came up in relation to her social security number?
The two business addresses that came up on the clear search were the 400 Chisholm Place, Suite 410, Plano, Texas 75075, and the 3125 Ipswich Drive, Plano, Texas 75025.
And is one of those addresses the respondent's address of record with the Accountancy Board?
Yes, the 400 Chisholm Place, Suite 410, Plano, Texas.
And does the Chisholm Place address appear to be a business address for the respondent?
Yes, it came up as a business address on the clear search.
In addition to the clear search, how else did you determine that this could well be a business address for the respondent?
We pulled it up on the website.
Okay. At this time, I'd like to show you a document and ask you to identify it for the record, please.
This is a printout of the PlanoCPA.com, the Locate Us page.
Okay, and if you look at the bottom right-hand corner of that website printout, what is the date on that?
It was printed June 9th, 2014.
Under the Locate Us tab, is there a street address listed for this business?
Yes, the 400 Chisholm Place, Suite 410, Plano, Texas.
And is there also an email address listed on this website? Read that for the record, please.
On the services page, there's info at theplanocpa.com, and up top, under call today, email jc@theplanocpa.com.
And is this document kept in the regular course of business of the Accountancy Board and maintained in Ms. Carlson Wall's complaint file?
Yes, we have it in our complaint file.
Your Honor, at this time, I'd request that this document be marked an exhibit, entered as Collective Exhibit 2 with permission to publish to the Board when Your Honor's review is complete.
The website information that has just been reviewed by Ms. Smith will be marked and entered into evidence as Exhibit number 2. You may pass copies to the Board.
As set forth in the Certificate of Service and the Notice of Hearing and Charges, was a copy of that document in fact sent to Ms. Carlson Wall at the 400 Chisholm Place, Suite 410, Plano, Texas address by certified mail?
Yes.
And what happened to that copy of the Notice of Hearing and Charges?
It returned to our office on July 23rd, 2014, returned to center, unclaimed, unable to forward.
Okay, and also as set forth in the Certificate of Service, was a copy of the Notice of Hearing and Charges sent to Ms. Carlson Wall at the 3125 Ipswich Drive address in Plano, Texas?
Yes, sir.
And what happened to that copy of the notice?
That one was also returned to our office undelivered on July 11th, 2014.
In addition to the certified mail efforts, did you also attempt to send a copy of the Notice of Hearing and Charges to the respondent via email?
Yes.
And first, did you send a copy to the jc@theplanocpa.com email address as identified on the website for the Plano CPA?
Yes.
And did that email bounce back as undeliverable?
No.
And did you also send a copy of the Notice of Hearing and Charges to the respondent at the email address of accountingdirect@yahoo.com, which is the email address referenced by Mr. Mills in his testimony earlier?
Yes.
And did that email bounce back as undeliverable?
No.
Okay. Turn now to your efforts to contact the respondent by phone. Approximately how many potential phone numbers for the respondent came up as part of your clear search?
4.
Okay. Was one of those phone numbers 972-208-2681?
Yes.
And did you attempt to call the respondent at that phone number?
Yes.
And on what date did you place that call?
I called on June 17th. I called on, just on June 17th on that one.
And what was the result of that phone call?
It was a recording stating that the number was disconnected or no longer in service.
Okay. And was another phone number from the clear search 972-618-8666?
Yes.
And did you attempt to call the respondent at that phone number?
Yes, on June 17th, June 19th, and June 23rd.
And what was the result of those 3 phone calls?
The phone just continued to ring. There was no answer or no voicemail to leave a message at.
Okay. was the phone number 214-431-4340 also a result from your clear search? And is that also the phone number identified as the business phone number on the Plano CPA's website?
Yes.
On what dates did you attempt to contact the respondent at that phone number?
June 17th, 19th, and 23rd.
What were the results of those 3 phone calls?
There was no ring, but it went straight to a voicemail identifying it as the Plano CPA.
And as you mentioned earlier, Plano CPA appears to be the name of the business from Ms. Carlson-Wall's website?
Yes.
Okay. And when you reached the voicemail recording at this number, what was the substance of the messages you left?
I stated that my name and that I'm a paralegal with Commerce and Insurance. I was calling regarding the hearing set for July 25th in front of the Board of Accountancy, and I stated that I was calling to verify if she received the notice of hearing and charges that was sent via certified mail and email on the 10th, and then I left my number, my direct extension, and requested that she call me back.
And did Ms. Carlson-Wall ever return any of those voicemails that you left at that number?
No.
And fourth and finally, did the phone number 214-563-2288 also come up as part of your clear search?
Yes.
And did you attempt to call the respondent at that phone number?
Yeah.
On what dates?
June 17th, 19th, and 23rd.
And what was the result of those phone calls?
The phone rang several times and then went to voicemail stating it was the voicemail of Jeanette Carlson Wall.
Okay. And when you reached the voicemail recording at this number on those 3 occasions, what was the substance of the messages that you left?
Essentially the same thing, that my name, that I'm a paralegal with Commerce and Insurance. I was calling regarding the hearing, July 25th. Calling to verify if she received the notice of hearing and charges, left my number and asked her to call back.
Did Ms. Carlson-Wall ever call you back in response to any of those voicemails?
No, sir.
Thank you, Ms. Smith. I have no further questions at this time.
Ms. Smith, do you have a copy of the notice of charges?
Yes, Your Honor.
On the back page of that, the certificate of service, when my office sent out the order that I sent out on June the 20th, we found that the address you had listed was incorrect for the number 1 address. It's just a misspelling of Chisholm.
Oh, yes, I see that.
Do you know what address you actually sent the envelope to?
I would have to look in the file. Do we have the file with this?
I believe we have the file right here, Your Honor, if you would like me to take a moment and try to locate that.
That was the one she testified was returned to sender. Do you have you should have gotten the envelope back.
Your Honor, I do have the cover letter that was sent with that. I believe the envelope is in my office. I was not aware of the misspelling, so I did not bring the envelope as part of the file. If I need to go get it, I can do that.
I can testify. I processed the mail that day, and it definitely said return to sender, unclaimed, unable to forward. It didn't say anything about improper address or not deliverable as addressed.
It would be helpful to have the envelope just because of that discrepancy.
Very well, Your Honor. Then if we could take a 5-minute recess,
We'll
I'll
take a
go.
5-minute recess. I saw refreshments that way. Members of the board, do not discuss the case amongst yourselves or with anyone during the break. Thank you.
Okay, Your Honor. What I have is the envelope that was sent to the Chisholm Place address, which came back by certified mail, unclaimed, as Ms. Smith testified, and also a USPS track and confirm printout for that as well. So whatever Your Honor would like to see, I'm happy to.
Like to see both?
Okay.
Okay, okay. All right, members of the board, I'm going to go ahead and then mark as exhibit number 3. Envelope that was returned, and Mr. Whitaker will pass copies to you all. Do a little stamp. And then as exhibit 4, we've got the tracking sheet for the same tracking code. Members of the board, I'll pass to you all the envelope also, which is, you're getting a copy of what's on it. That way you can all identify that as well. It looks like, Ms. Smith, the address you all used was misspelled, but it looks like it's probably a fairly frequent misspelling of Chisholm. It just doesn't have the H. You all spelled it Chisholm without the H. But it has come back from the post office, returned to sender, unclaimed, unable to forward. So I assume, members of the board, that the post office was able to figure out where it was supposed to be going. The order that my office sent out on June the 20th of 2014, which I mentioned to you all earlier as the second entry in our technical record, it was addressed to Chisholm, spelled Chisholm, and that has not been returned to my office either. And my order also, in the first paragraph, gave notice that the hearing was set today at 9 a.m. in conference room 1A on the first floor of the Davy Crockett Tower with the address, which is, of course, where we are. So I'll pass the order that I sent out so you all can see that they were giving another. She was given notice, let's just go with a third time there, from my office of today's hearing date, time, and place. Are there any questions for Ms. Smith from the members of the board? Mr. Whitaker, do you have any other questions for Ms. Smith?
I do not, Your Honor.
All right. Thank you. Any other proof with regard to proof of service?
No, Your Honor, at this time.
Does the state have a motion?
Yes, Your Honor. The state would move that the respondent, Jeanette Carlson Wall, be held in default and the state be allowed to proceed with this formal hearing pursuant to TCA 4.5-309, Secretary of State Rule 1360-04-01-.5, in the case of Johnson versus Tennessee Board of Nursing, 2007 Westlaw 624353. And the attempts at proof of service entered, we would request that this hearing be allowed to proceed in default.
Thank you, Mr. Whitaker. Members of the board, the rule that Mr. Whitaker just cited you to under the Uniform Administrative Procedures Act rules is 1360-04-01-.06, and it's in subparen 3, where we look at issues such as whether any attempts at actual service were made, whether and to what extent actual service is practicable in any given case, what attempts were made to get in contact with the party by telephone or otherwise, and whether the agency has actual knowledge or reason to know that the party may be located elsewhere than the address to which the notice was mailed. Based upon the testimony and the exhibits submitted by Mr. Mills and Ms. Smith, I think that the state has satisfied those requirements of that rule with their many attempts at contacting the respondent in this case and serving her with notice of hearing. And in addition, as I passed that order to you all, my office, while ours was not certified mail, we did send an order to both addresses that the department had given us, and neither of those have come back returned to my office also. Based upon that, I find that the service of the notice in this case was sufficient and proper under the statute and rules that apply in this case. The question goes to you all as the members of the board to determine the issue of whether or not to hold the respondent in default in today's proceedings. Default is proper when a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case. In that event, the party may be held in default pursuant to Tennessee Code Annotated Section 4-5-309, Subpart A. That statute reads as follows. If a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case, the administrative judge or hearing officer hearing the case alone, or the agency sitting with the administrative judge or hearing officer, may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having due regard for the interest of justice and the orderly and prompt conduct of the proceedings. So at this time, Mr. Chairman, I will turn it over to the members of the board for you all to determine whether or not you would like to hold the respondent in default and proceed with this case as an uncontested case.
I will entertain a motion.
I'll move that we hold the respondent in default and proceed.
Second that
Have a
motion,
motion. Mr. Royston has seconded that motion. Any discussion? Do you want us to do a roll call, Your Honor, for this? Or
I
does
think
it
it's
matter?
always helpful.
Okay. Mr. Alexander, if you could start with a roll call if you're in favor of the motion.
Favor?
State your name.
Vic Alexander, I'm in favor.
Okay.
In favor. Stephen Eldridge.
Casey Stewart, I'm in favor.
Trey Watkins, I'm in favor.
Bill Blofeld, I'm in favor.
Troy Brewer, in favor.
Don Royston, in favor.
Charlene Spiceland, in favor.
Henry Haas, in favor.
Your Honor, the motion has been accepted by the board.
Thank you, members of the board. Mr. Whitaker, the board has considered the motion for default and has granted the motion for default. So at this time, we will proceed with the contested case itself. Members of the board, today I will make all of the rulings regarding the order of proceedings, the admissibility of evidence, and the questions of law under the authority granted to me by the Tennessee Administrative Procedures Act. But I will not participate in the findings of fact or the ultimate decision of the board. Those decisions will be made by you at the conclusion of the proof today. You should not draw any conclusions until all of the proof has been submitted, and you should listen openly to the proof during the hearing and make your decision at the conclusion of the proof. Mr. Whitaker, would you like to make an opening statement?
Yes, Your Honor. Thank you. Just very briefly. Good morning, members of the board. For the record, my name is Chris Whitaker, and I'm the Assistant General Counsel for the Department of Commerce and Insurance Regulatory Boards Division. I represent the state in this matter. A formal hearing against the respondent, Jeanette Carlson Wall, CPA licensed in the state of Tennessee, for her alleged violations of the Tennessee Accountancy Act of 1998 as amended and the rules promulgated thereunder. In this case, the conclusion of the proof, the state expects to prove the following facts. That Ms. Carlson Wall was, at all times relevant to the matters of this formal hearing, a CPA licensed by the Tennessee State Board of Accountancy or required to be licensed, that Ms. Carlson Wall's Tennessee CPA license expired on or about December 31st, 2013, that Ms. Carlson Wall failed to timely pay her professional privilege tax as required by law for 4 tax periods, that the Texas State Board of Public Accountancy revoked Ms. Carlson Wall's Texas CPA license and firm permit, that Ms. Carlson Wall failed to notify the Tennessee State Board of Accountancy of the revocation of her Tennessee CPA license and firm of her Texas CPA license and firm permit in a timely manner as required by law, and that Ms. Carlson Wall failed to timely respond to either of the complaints which are the subject of today's formal hearing. As a result of these violations, the state seeks the revocation of Ms. Carlson Wall's Tennessee CPA license for a period of 5 years, provided that she may apply for reinstatement at any time within that 5-year period if she demonstrates with compliance with all terms of any lawful order, final order of the board in this matter. The imposition of a civil penalty against Ms. Carlson Wall in the amount of $2,000 for $1,000 for the failure to timely pay her professional privilege tax for 4 periods, and $1,000 for the revocation of her Texas CPA license and firm permit, and her failure to notify the Tennessee Board of said revocations. State would also request a requirement that Ms. Carlson Wall provide written documentation from the Tennessee Department of Revenue that she is current on her PPT obligations, including interest and penalties, or that she has entered into a written payment arrangement with the Tennessee Department of Revenue regarding her delinquent privilege tax, including interest and penalties. Thank you.
Thank you, Mr. Whitaker. Who would you like to call as the state's first witness?
State calls Mark Crocker.
I'll do it standing.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat.
Morning, Mr. Crocker. Can you please state your name and position for the record?
My name is Mark H. Crocker, and I'm the Executive Director of the Tennessee State Board of Accountancy.
How long have you been the executive director for the board?
October of 2007.
And are you also the custodian of records for the board?
Yes, sir, I am.
And have you reviewed the licensing and complaint files of the respondent, Jeanette Carlson Wall, prior to your testimony today?
Yes, sir, I have.
And based on your review of those files, has Ms. Carlson Wall ever held a Tennessee CPA license?
Yes, sir, she has.
And what is her Tennessee CPA license number?
Her license number is 17273.
And as of the date of this formal hearing, is Ms. Carlson Wall's Tennessee CPA license current and in good standing?
No, sir, it is not.
Okay. And is that Tennessee CPA license currently expired?
Yes.
And on what date did Ms. Carlson Wall's Tennessee CPA license expire?
Her license expired on December 31st, 2013.
As of the date of this hearing, has Ms. Carlson Wall made any attempts to renew her license or to bring it current?
No, sir.
And absent disciplinary action by the board against Ms. Carlson Wall's Tennessee CPA license in this matter, could Ms. Carlson Wall pay all past due fees, meet any other applicable license requirements, and have her Tennessee CPA license reinstated to good standing?
Yes, sir, she could.
Okay. With the complaints in this matter, how did Ms. Carlson Wall first come to your attention?
She came to my attention because she was on the list of licensees who had failed to pay their professional privilege tax for at least 2 periods.
And did the board open a complaint against Ms. Carlson Wall on that basis?
Yes, we did.
Your Honor, my paralegal hasn't returned, so.
You're paralegal.
Mr. Crocker, I'd like to show you a document at this time and ask you to identify it for the record, please.
This appears to be our initial complaint document opened against Ms. Wall, Carlson Wall.
And based on the document before you, what is the date this complaint was opened?
This looks like it was opened June the 19th, 2013.
Is this document maintained and kept in the regular course of business of the Accountancy Board?
Yes, it is.
Is it also maintained and kept in Ms. Carlson Wall's complaint file?
Yes, it is.
Your Honor, at this time, subject to Your Honor's review, request that this complaint document be entered as, I believe we're on Collective Exhibit 5. Is that
We
correct?
are.
Okay. By happy coincidence, I think that's correct.
It is. Members of the board, the complaint that Mr. Crocker has just identified will be marked and entered into evidence as Exhibit number 5, and you all may pass copies to the board.
Your Honor, there are two complaints in this matter. I think the one that I realized that when Mr. Crocker read the date, I think we're dealing with the other complaint for the revocation. And it appears that is the privilege tax complaint, so we need to swap that. Or I can go ahead with the questions on the revocation complaint and then go privilege tax, whatever Your Honor's pleasure.
And why don't we go ahead with the revocation since we've already identified it?
Okay.
That's the one that's Exhibit 5?
Yes, Your Honor.
Okay.
Mr. Crocker, looking at the complaint file, or the complaint document in front of you, what are the allegations in that complaint document?
Allegations in this one are that she failed to notify us of the revocation of her Texas license.
Okay, and is it a violation of the accountancy statute and rules for a Tennessee CPA to have their license revoked in another jurisdiction?
Yes, it is.
And is it also a violation of the Accountancy Act and rules for a Tennessee CPA to fail to timely notify the board in writing of the revocation of their license in another jurisdiction?
Yes, it is.
Okay. And do the revocation of Ms. Carlson Wall's license and firm permit in Texas and her failure to notify the board in writing in a timely manner constitute violations of the Accountancy Act and the rules?
Yes, sir, it does.
Okay. Mr. Crocker, I'm going to hand you a set of documents at this time and ask if you can identify them for the record.
This appears to be the documentation that we received from the Texas Board of Accountancy outlining the action they had taken against Ms. Carlson Wall and their basis for doing so.
Okay, and I'd like to direct your attention to the first page of the set of documents I just handed you. Can you specifically identify that document for the record?
This is a certificate and business records affidavit from William Tracy, who is the executive director of the Board of Accountancy for Texas, stating that everything attached is true and absolute copy.
Okay, and are these documents also maintained and kept in the regular and ordinary course of business of the Tennessee Accountancy Board?
Yes, sir, they are.
And on that document, does it appear that there is a state seal from the state of Texas?
Yes.
And these documents are kept in Ms. Carlson Wall's complaint file in the ordinary course of business as well? Your Honor, pursuant to Tennessee Rule of Evidence 803 sub 6 relative to business records and Tennessee Rule of Evidence 902 sub 1 relative to self-authenticating documents, I request that this set of documents be entered as Collective Exhibit 6.
The documents Mr. Crocker's just identified from the Texas State Board of Public Accountancy will be entered. It's a series of documents, so it's really going to be a collective exhibit, but it is only one certification here on the top from Texas, and that will be marked and entered into evidence as Exhibit number 6, and you may pass copies to the board.
Mr. Crocker, after reviewing the documents submitted to the Tennessee Board by the Texas Board relative to Ms. Carlson Wall, can you determine why her Texas CPA license and firm permit were revoked?
Well, it appears that in May of 2011, the Texas Board fined Ms. Carlson Wall $2,500 plus costs for offering accounting services from an unlicensed firm and for engaging in deceptive advertising on the firm's website in violation of Texas law. She subsequently failed to pay the civil penalty assessed by the 2011 order and did not respond to the Texas Board's attempts to communicate with her regarding the satisfaction of the terms of that order. Based on that, the Texas Board revoked Ms. Carlson Wall's Texas CPA license and her firm permit.
Okay, so in light of the revocation of Ms. Carlson Wall's Texas CPA license and firm permit, in your opinion, is the board within its authority to impose discipline against Ms. Carlson Wall's Tennessee CPA license on that basis?
Most definitely.
Based on your review of Ms. Carlson Wall's licensing and complaint files for this board prior to your testimony today, did she timely notify the Tennessee Board of the revocation of her Texas CPA license and firm permit as required?
No, sir, she did not.
And does that failure to timely notify regarding the Texas revocations also constitute one or more violations of the Accountancy Act and rules?
Yes, sir, it does.
And the board, in your opinion, is the board also within its authority to impose discipline against Ms. Carlson Wall's Tennessee CPA license on that basis?
Yes, sir, it is.
All right, Mr. Crocker, I'm going to go back to the professional privilege tax complaint document at this time. And I'd like to show that to you, and I'd have you identify it for the record.
This is a copy of the complaint document that was filed to open the complaint against Ms. Carlson Wall for failure to pay her professional privilege tax as required in Tennessee.
Okay, and on what date was that complaint opened?
This complaint appears to have been opened on December the 14th of 2012.
Okay, and is this document maintained in the regular and ordinary course of business of the Tennessee State Board of Accountancy?
Yes, it is.
And is also maintained in Ms. Carlson Wall's complaint file?
Yes, sir, it is.
Your Honor, at this time, I'd move that the complaint documents for the professional privilege tax violations against Ms. Wall be entered into evidence as Collective Exhibit 7, I believe we're at.
Yes. The document that relates to the professional privilege tax complaint will be marked and entered in evidence as Exhibit number 7. I think the copies you all are getting are pre-marked as Exhibit number 3. So if you all would scribble 3 out and write 7 on your copies, then when you ask questions yourselves, you'll know what you're referring to. It hadn't gotten there yet. It's on its way, I think. So, yeah, you may go ahead and pass it.
Mr. Crocker, at this time, I'd like to show you another document and ask if you can identify it for the record, please.
This is a memo from the Department of Revenue outlining individuals who are delinquent, regarding Jeanette Carlson Wall, license number 17273, indicating that Ms. Wall is past due for 4 periods in her professional privilege tax.
Okay, and based on this memo, what are those tax periods?
Those tax periods are 09 through 10, 11 through 12, 12 through 13, and 13 through 14.
Okay, and what is the date on this document?
The date on this document is June the 10th, 2014.
Okay, and is this document maintained and kept in the regular and ordinary course of business of the Accountancy Board?
Yes, sir, it is.
And is it also maintained in Ms. Carlson Wall's complaint file?
Yes, sir, it is.
Your Honor, at this time, I'd move that this professional privilege tax delinquency memo from the Tennessee Department of Revenue relative to Ms. Carlson Wall's Tennessee CPA license be entered into evidence as Exhibit 8.
The June 10th, 2014 2014 professional privilege tax memo from the Department of Revenue regarding the respondent will be marked and entered into evidence as Exhibit Number 8, and you may pass copies to the board. Is that pre-marked?
I believe this one is marked as number 4.
If you all would scribble out the 4 on your copies and make that an 8, that would be good.
Mr. Crocker, according to this memorandum, what is the amount of past due privilege tax owed by the respondent, including interest and penalties?
Well, they indicate that the current outstanding balance is $2,201.20, but then when you add up all the amounts that they have due for the individual period, it comes to $2,236.70.
Is that $2,236.70 the amount alleged in the notice of hearing and charges in this matter?
Yes, sir, I believe it is.
So theoretically, it could just be a math error computing those 4 amounts owed together by the Revenue Department?
Yes, sir, I think so.
Okay. Relative to both complaints in this matter, the privilege tax and the Texas revocation complaints, did the board transmit copies of those complaints to Ms. Carlson Wall's address of record with the board prior to today's hearing?
Yes, sir, we did.
And did Ms. Carlson Wall respond to the original complaints that were sent to her in any way?
No, sir, she did not.
And is it a violation of the Accountancy Act and the rules promulgated thereunder for a Tennessee licensed CPA to fail to respond to a disciplinary complaint in a timely manner?
Yes, sir, it is.
And in your opinion, does Ms. Carlson Wall's failure to so respond constitute a violation of the accountancy statute and rules?
Yes, sir, it does.
Thank you, Mr. Crocker. I have no further questions.
Thank you, Mr. Whitaker. Members of the board, do you all have any questions for Mr. Crocker?
Mr. Crocker, did you say that the license she has not cleaned up her license in Texas, is that correct?
No, she is not.
Okay.
Mr. Crocker, I may have missed this, but did she hold a Tennessee license on the basis of reciprocating with Texas or vice versa? I guess I would say, was she originally certified in Tennessee or in Texas?
Stewart, it looks to me that she was originally certified in Tennessee.
Any other questions for Mr. Crocker? Mr. Whitaker, any other questions for Mr. Crocker?
No, Your Honor.
Thank you, Mr. Crocker.
Your Honor.
Does the state have any other proof?
No, Your Honor. The state's proof is concluded.
All right, would you like to make a closing argument?
Yes, Your Honor, just very briefly. Members of the board, now that the proof in this case has been concluded, the state submits that it has proven the allegations against Ms. Carlson Wall as outlined in the notice of hearing and charges. Based upon the documentary evidence and witness testimony at today's hearing, the state respectfully requests the revocation of Ms. Carlson Wall's Tennessee CPA license for a period of 5 years, provided that she may reapply for reinstatement at any time within that 5-year period if she demonstrates compliance with all terms of any order entered by the board in this matter. The imposition of a $2,000 civil penalty against Ms. Carlson Wall, which is $1,000 for failure to timely pay her privilege tax for 4 periods as required by law, and $1,000 for the revocation of her Texas CPA license and firm permit and her failure to timely notify the board of said revocations, and the imposition of a requirement that Ms. Carlson Wall provide written documentation from the Tennessee Department of Revenue. She is current on her privilege tax obligations, including interest and penalties, or that she's entered into a written payment agreement with the Department of Revenue regarding her delinquent privilege tax prior to the board reinstating her license in Tennessee. Thank you.
Thank you, Mr. Whitaker. Members of the board, you have now heard the proof in the case of the Tennessee Department of Commerce and Insurance versus Jeanette Carson-Wall. which is docket number 12.19-126286A. It is now my duty to charge you as to the law you must follow in reaching your decision this morning. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law, specifically your statutes, rules, and regulations and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondent has violated certain of the state of Tennessee's applicable statutes and rules. It is the state's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence presented. You must limit your inquiries this morning into the violations of rules and statutes that were identified and specifically alleged in the state's notice of charges, a copy of which was given to you on your iPads at the beginning of the hearing. And you must base your determination solely on the evidence presented to you during today's hearing. The evidence consists of the testimony given by the witnesses during the hearing and the exhibits introduced into evidence, which you may review during your deliberations. And I believe copies were handed to you of all the exhibits, but if anyone's missing one, I have the originals as well. Statements and arguments by the attorney for the Department of Commerce and Insurance and the documents contained in the technical records, such as the notice of charges, which is the document on your iPads, and any proposed order that the state should submit are not considered evidence. You may use these arguments and documents to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and a determination that those documents accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. Although you may only consider the competent evidence that was presented during today's hearing in making your decisions, this does not mean that you are required to set aside your common knowledge or expertise in the field of accountancy, and you may and in fact should weigh the evidence in light of your training and own observations and experience. You should always keep in mind that the state of Tennessee bears the burden of proving the charges in this case. The respondent does not have the burden of proving that she is innocent. Your final order should contain 4 sections. Number 1, findings of fact. Number 2, conclusions of law. Number 3, a decision regarding what disciplinary action shall be taken, if any. And number 4, the policy reasons for your decision and determination. Within any disciplinary action section, you should also identify any civil penalty or any cost that you want to attribute and assess towards the respondent. In making findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and the documentary evidence admitted. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges. And if so, you must state those determinations in your conclusions of law portion of your final order. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate the linkages and connections between the 2 sections of your final order. If you decide that there has been a violation of a state statute or rule, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary actions they take. However, this does not mean that you may make arbitrary and capricious rulings in dealing out disciplinary actions. Disciplinary actions must be based on fairness and reason. Finally, a policy reason must accompany your determination. This policy reason should state why the decision you're rendering today in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your deliberations must be in public before all parties. If you need, or all parties that chose to be here this morning. If you need assistance with the law or the structure of your order, I am available to assist you. If you have any questions about the facts presented, you may by majority vote reopen the proof and hear further testimony for witnesses and/or argument from counsel. Mr. Whitaker, I believe you mentioned that you have a proposed order?
Yes, Your Honor.
Is that on the iPad, I think? Or not?
No, Your Honor. As I mentioned earlier, didn't believe it was appropriate to have that in advance.
Okay.
So we have hard copies of that
Okay.
to publish to the board.
All right, you may do that now. Members of the board, Mr. Whitaker is passing to you all proposed findings of facts and conclusions of law that you may consider during your determination. Remember, you are not bound by the state's proposed findings and conclusions. Instead, these are only being submitted as a guideline as to what counsel for the state thinks the proof has shown this morning. It is up to you to determine what has actually been proven in this case. At this time, unless members of the board have questions regarding my charge, I will turn the proceedings over to the board chair to preside over your deliberations, after which you will make findings of fact, reach conclusions of law, including a decision regarding any disciplinary action, and finally, a policy reason for your decision. Mr. Chairman?
Thank you, Your Honor. Everybody will just take a moment to review the proposed findings of fact and conclusions of law, and then we'll open discussion.
And for the record, I'm going to enter the proposed order as technical record entry number 4, so it will be part of the file. It's not evidence, as I said, but it is part of the file.
Can he, Your Honor, he has a question about I assume it's the proposed findings and facts and conclusions of law?
Yep.
For Mr. Whitaker, or?
Yeah, Mr. Whitaker.
What's the question?
Says the board should assess a civil penalty of $2,000, but then in numerical, it's got $3,000 numerically.
Mr. Whitaker, we're looking at page
Page 2.
2. Were you looking for $2,000 or $3,000?
Your Honor, it's actually $3,000. That is a typographical error. If you look back to the final pages where the proposed disciplinary action, it's actually $3,000, and that is simply a typo.
Thank you. Go ahead, members of the board.
Chairman,
Yes, sir.
can we just adopt the proposed findings of fact?
I think that's a question, I assume, Your Honor, we can, I have done that. Certain
Can we accept that?
judges want things done differently, so.
Well,
I think what we're probably leaning towards here is that these are pretty basic charges, and we would like to accept, or there is a potential motion to accept the findings of fact and conclusions of law as just given to us. I don't know how Your Honor feels about that.
What you want to do is just remember, your deliberations are in public. We're making a transcript of the hearing. So you want the record, which is the resultant transcript, to be able to identify to any appeals court what you've done today. So it's up to you all how to go about adopting something, but you want to make sure the record's clear as to what you're adopting.
Got it.
So such as, can we adopt the findings? That, in my opinion, isn't really clear enough. I think you need more specificity.
Yeah, I was just asking the question, if that's what, if we can, then maybe we need to read this into the record as to be the findings that we have determined.
I agree with that. Let's just, do you want to entertain a motion to enter in the findings into the record?
And conclusions of law.
And the conclusions of law?
I would do it as two separate topics,
Okay.
just because that, again, separate parts of your order. Start with findings of fact, because if there, for example, if there were something you wanted to delete, you'd want to make that clear, or if there were something you wanted to add, you'd want to do that in that one section and then go on to the conclusions of law.
Is everybody in agreement on that? We've got the motion, I guess. I guess we need a motion to adopt that we're going to do this. Do I have a second on that?
Could we stipulate the numbers, or we're going to adopt the proposed finding of facts 1 through?
Your Honor, is that specific enough in your opinion, or do you feel like we need to read these 3 pages of it?
If I were doing it, I
You
would
would
read
read
the
it.
3 pages.
Okay.
It's however you all want to do it.
I
But
think
again-
we're just going to do that.
Again, just think of what you're doing.
Yes.
You all want to make your record clear to anyone who reads this later what you all did.
All
That
right.
make sense?
I have a motion. I have a second. Any discussion? All those in favor of reading or I guess accepting the findings of facts and conclusion of law and introducing those into the record, please do so by roll call vote.
Vic Alexander, yes.
Even, yep.
We're going to actually have this.
Asking us to do.
Again, it's up to you all how you want to do it. If you want to read them, but you'd want to read it before you vote on it, if that's what you're going to do, if that makes sense.
How about this? Let's adopt 1 through 13 and take our chances. And then we can vote on that. Are y'all okay with that? Not reading it. I will identify them as 1 through 13
In exhibit.
in exhibit.
Not an exhibit.
Not an exhibit.
What is it? What did you call it?
It's a proposed order submitted by the state.
But you had entered it into some form of
It's
the record.
technical record entry number 4, but
Technical.
again, it's, as I said in my charge, this isn't evidence. This is merely the recommendation of the state, and your deliberations should show that you all concur with what's in it if you're going to adopt it.
Gotcha. All right, let's start this again. Let me have a motion, please, to adopt the findings and fact and conclusions. We are considering proposed findings of facts 1 through 13 in the document titled Proposed Findings of Facts and Conclusions of Law as provided by the state.
Found on pages 2, 3, 4, and 5.
Right. Found it on pages 2, 3, 4, and 5 of that document. Do I have a motion to accept those findings of fact?
So moved.
Okay, I have a motion by Mr. Hoss. Do I have a second?
Second.
Second by Mr. Royston. Any discussion?
We include the reference number that the judge mentioned, item, what was it? evidence of,
Technical,
evidence to forward. Would you reference this document? What number? Should
Technical record entry number 4.
we include that in there to be more specific?
okay.
The motion?
Mr. Hoss, do you want to revise that? Are you okay with that amendment? Technical record entry number 4?
Yes, that's fine.
Okay. I'll
Accept
re-second
that
that. Okay.
amendment.
Any other discussion?
Mr. Chairman?
Yes.
I'd like to point out that in paragraph 2, that the address is misspelled, and we have previously discussed the spelling of that address and found it to be incorrect, and that needs to be pointed out.
Can actually correct it since you're the one drafting the order. You're not bound by what they've given you.
Tell you what, Mr.
your
Halls.
order, not
let's
their
do 1 through 13 excluding 2, and then we'll do 2 separately with the amendment of the address. How about that?
That's fine.
Okay. So can you redo your motion one more time? To accept 1 through 13 excluding 2.
I'd like to make a motion that we accept paragraphs 1 through 13 excluding paragraph 2 in the proposed findings of fact.
Second that motion.
On pages 2 through
through
5 and the
Of
and the
proposed
technical
findings.
record entry number 4.
Right.
Okay. Mr. Royston, do I have a second on that?
Do.
Okay. Any further discussion? Okay. Hearing none, those who are in favor of adopting the findings on pages 2 through 5, please do so by roll call vote.
Alexander, I'm in favor.
Stephen Eldridge in favor.
Casey Stewart in favor.
Ray Watkins in favor.
Bill Bluffus in favor.
Troy Brewer in favor.
Don Royston in favor.
Charlie Spiceland in favor.
Henry Hoss in favor.
Mr. Hawes, can I have a
Mr.
recommendation?
Chairman, I would recommend that we adopt paragraph number 2 found on page 2 of the proposed findings of fact with the one change of the spelling of the address where it says 400, it should be CH, what is that? CHISHOLM?
All right, that's correct. Okay, I have a motion on the floor. Do I have a second?
Second.
Okay, Mr. Brewer has seconded. Any discussion? All those in favor of adopting proposed finding of fact number 2 with the amendment proposed, please signify with a roll call vote.
Alexander in favor.
Stephen Eldridge in favor.
Casey Stewart in favor.
Ray Watkins in favor.
Bill Bluffus in favor.
Troy Brewer in favor.
Don Royston in favor.
Charlie Spiceland in favor.
Henry Hoss in favor.
Okay, now we have to do the conclusions of law. Do I have a motion on that?
Mr. Chairman, is that what we're looking at here on pages 5, 6, 7,
I believe that is correct.
up through top part of page 10?
That I do believe is correct. So it'd be 1 through 12.
Make a motion that we adopt the conclusions of law, items 1 through 12, indicated on pages 5 through part of page 10, as included in the proposed findings of facts and conclusions of law.
That's technical record entry number 4.
Second.
Okay, I have a motion, I have a second. Any discussion? Hearing none, all those in favor of adopting the conclusions of law as identified by the motion, please do so through roll call vote.
Alexander in favor.
Stephen Eldridge in favor.
Casey Stewart in favor.
Trey Watkins in favor.
Bill Bluffus in favor.
Troy Brewer in favor.
Don Royston in favor.
Charlie Spiceland in favor.
Henry Hoss in favor.
That motion has passed, and we've adopted the conclusions of law. I guess next we have to discuss the disciplinary, civil, and administrative costs. Those, I believe, are identified on pages 10 through 12 as recommended by the state.
I move that the counts 1, 2, and 3 as outlined on pages 10, 11, and 12 be approved.
That is in the statement of findings of fact and conclusions of law, technical record entry number 4.
I'll second that.
Okay. I have a motion. I have a second. Any discussion?
Chairman, I just wondered a little bit about the fact that a lot of this is based on her activity in Texas and her getting her license removed in Texas. And I was just wondering if there would be a need here, since we're basing this on a lot of activity that she conducted in Texas, that before she would get relicensed in Tennessee, that we would want to know where she stands with the state of Texas. And it seemed like that she would need to show some kind of proof to us on her, any kind of clarification that she's had with the state of Texas.
That would
Now,
be.
that may be a little bit far-fetched, but it just seemed like that since we're basing a lot of this on what she was doing in Texas, that we ought to at least have some.
Well, it seems to me on page 12 in that last paragraph where it addresses that the revocation of the license for a period of 5 years and require that the respondent provide written documentation to the board demonstrating compliance with professional privilege tax obligations to the Tennessee Department of Revenue. And you could also, I guess, add in there, if you'd like, that other violations in other states be provided a written clearance or whatever you want to call it from those boards as well. If you'd like to amend something like that, that would probably be.
If I can add something, that the only thing about that is that's just the requirement for her to apply. That doesn't mean that this board would accept that application.
The other thing is it's up to our administration to, before this is brought back to us, to make sure that all of that has been taken care of in Texas.
I guess that's in essence what
That's
I'm
what you're
saying.
saying, yeah.
When she applies, whoever the board is at that time, I believe will make sure that she's met all of her obligations in order to grant her another license. It's just saying she's got to pay the fees to even be able to apply.
If I could interject a suggestion. Your motion included these 3 different recommendations.
Yes.
Count number 2 on page 11. And count number 3, that starts at the bottom, those appear to deal more with the Texas issue than count number 1. Count number 1 seems to deal more with the professional privilege tax. So if you want to add that kind of requirement, you might want to add it to either 2 or 3 instead of 1. Does that make sense?
I think I agree with Mr. Alexander, though, that I'm not sure putting that in this order is completely necessary, because I do feel like before we reinstate a license, we will be discussing the issues that caused the loss of the license to begin with.
Yep.
Does that satisfy you, Henry? Okay.
I just wanted to throw it out for discussion.
Right.
I just wanted to make sure that later on, that, this Texas issue gets brought back up.
Okay. We did have a motion. Yes. I'm sorry, I lost my place. A motion and a second. And any further discussion on this matter? Hearing none, let's do a roll call vote to accept the civil and administrative cost pays.
Vic Alexander in favor.
Stephen Eldridge in favor.
Casey Stewart in favor.
Trey Watkins in favor.
Bill Bloffelson in favor.
Troy Brewer in favor.
Don Royston in favor?
Darlene Spiceland, in favor.
Henry Haas, in favor.
Mr. Chairman, your motion was to adopt the civil and administrative cost. There are two issues there. One is civil penalties, and one is administrative cost. It's two separate concepts. So I think for clarification of the record, you may want to also have a vote with regard to the disciplinary action and civil penalties.
I have a motion on the clarification of the the penalty and the administrative cost.
No, you've already done administrative costs. That's what you just
Okay.
did. What I'm saying is, you're the way you phrased that motion, you did not.
I did not make the motion. I was just repeating. That was not a proper
The way you
motion.
phrased what you all just voted on did not mention disciplinary.
That was not the original motion that was
Action.
taken. I just was paraphrasing.
What was the
The
original
motion that I made was to adopt in totality the counts outlined on pages 10, 11, and 12.
I agree, Mr. Bluffus. What I'm saying is the way he rephrased it when y'all did a roll call vote.
That is my fault. Let's
Again,
do this
I'm
again.
I'm just trying, no, what I'm saying is that part's fine with
I got
regard
you.
to cost.
But if we
But
do,
you-
if
you're
we
doing
do
roll
count
call
1,
votes-
2, and 3 again, and I don't speak,
Let's
then
have
I
Mr.
think we'll
Bluffus
be
make the
covered.
motion this time again.
Okay, did we need to remove the last motion?
No, the motion with regard to the cost is fine. I'm
Okay.
just saying, so that the record is clear, I think it would help if y'all had a roll call vote on the disciplinary action portion of his motion.
Okay, is that not what's outlined in 1, 2, and 3?
It is, but the way you identified it right before the roll call vote did not sound like that's what you were asking them to vote on.
I make a motion that we accept counts 1, 2, and 3 disciplinary actions in the document, finding of facts.
No,
Te-
you're in conclusions of law.
Oh, conclusions of law, okay. Technical record number 4, on pages 10, 11,
11,
and
12.
part of 12.
That would include the penalties proposed as well.
No, we've already voted on the
No,
penalty.
No,
you
we
voted
didn't.
on the cost
demonstrated.
assessment. You
Oh,
haven't
okay.
voted on the
And the
penalties.
penalties.
That's my whole point, is if you're going to assess $3,000 in penalties, the board needs to make it clear here today on your record, that's what you're doing.
My second then includes all the counts 1, 2, and 3 in the administrative record, number 4, including the penalties and assessed, and the actions, the disciplinary actions.
Who's making the motion?
He
They're
did.
the
You made the
I
motion,
seconded
you
it.
seconded.
Mr. Royston seconded.
Any discussion? All those in favor of the motion, please do so by roll call vote, starting with Mr. Alexander.
Alexander in favor.
Stephen Eldridge in favor.
Casey Stewart in favor.
Ray Watkins in favor.
Bill Bluffus in favor.
Troy Brewer in favor.
Don Royston in favor.
Darlene Spiceland in favor.
Henry Haas, in favor.
Okay, so now we're into the policy reason. Okay, I'm going to do my best here, Your Honor. It is the purpose of this board to protect the public and ensure that our profession complies with the rules and regulations of the state of Tennessee. We do here find that Mrs. Wall has violated those rules and regulations, and hereby have adopted the penalties that we did today in light of her actions. Do I need to go further? Is that good? Thank you.
Got a motion to adopt it?
So moved.
Second.
I have a motion to adopt, a second. Any discussion? Hearing none, please vote to accept the motion with roll call vote.
Alexander, I accept the motion.
Stephen Eldridge accept the motion.
Casey Stewart, accept the motion.
Ray Watkins, accept the motion.
Bill Bluffus, accept.
Troy Brewer, accept.
Don Royston, accept.
Darlene Spiceland, accept.
Henry Haas, accept.
Mr. Whitaker, the board has adopted the proposed findings of fact and conclusions of law as set forth in your proposed order. If you would draw up the order for the chair's signature and have that filed with my office, that order will become a final order effective of the board the date it's filed in my office. And if you would include appeal rights for the respondent in that order, and of course also include because this was a default proceeding under our statute, you'll need to have a paragraph that also identifies the fact that the board held the respondent in default and proceeded in an uncontested case.
Yes, Your Honor, I'll be glad to do so. Just one question for the chairman. Mr. Chairman, if by some chance you're unavailable when this order is ready, would you like to vote to authorize Director Crocker to sign in your stead?
I would like that. That'd be fine.
Okay. If we can.
Thank you. Members of the board, why don't we take a 10-minute break before we have our next hearing?
Just a second, board. I do want to make sure, I don't know if I've told everybody here, I've got to leave by 1 because I've got a flight at 7 out of Memphis. But I do want to get to the voting of the officers for the next term before I leave. So
Y'all want to do that?
If y'all want to, well, I do want to give you a break just before we do that.
If you'd like to.
Yeah, I'd like to just have y'all think about that while we take this 10-minute break. And if you're in favor of doing so, I would like to knock that item off the list if at all possible. So be thinking about your nominations, and then maybe we could address that before 1. As far as I know, there's no slate at this point. There are some motions out there, but I'll let Mark bring those to the table. Okay, thank you.
We're going to do better.
Out a little bit of this, so I'll give just a minute here for Mr. Brewer and Mr. Royston to get up here.
While y'all are gathering, I need the original stack of exhibits that were over there with all the witnesses. Goody.
They collected them.
Okay, just real quick to hit some of these committee reports. Troy, do you have anything on the UAAC?
I do have a brief summary. The UAA. Let me get to my notes. We had a no, it's okay. We had a conference call July the 8th. This would have been regarding, if I can see this correctly, substantial equivalency concepts. I think we've, like I say, it was a conference call July the 8th. And this is, in essence, we're trying to get states equivalent to each other as far as requirements to apply for a CPA license. At this point, like I said, I'll try to be brief here. I mean, we're to do this substantially. You need a degree. You need 150 hours. You need 1 year experience, and you need to have completed the CPA exam. Now, this would be under Section 23 of the UAA Act. And so what we had is we had some states that we needed to make some adjustments to. And we had some, there's 2-tier states which certificates are initially obtained, and then you have to meet additional requirements to apply for the license. And then you have states that had more than one path. And these states, which is our conversations were about these states, would have been California, Colorado, and the Virgin Islands. And as we got toward the end of the conversation, we talked about the Virgin Islands pathway the most, because at this point in time, or at least last year, you could have a high school degree and apply to get a CPA license. I think they had a path that you were able to do that. So we had a few states that we were trying to reword part of the act to get them up to the specifications, the 4 that I talked about first. These states, they will be phased out and will be required. I think the Virgin Islands, when it's phased out, I think will be to where you have to have 120 hours, and then you have to have an approved college graduation, has to be approved by the board, and then 3 years of accounting practice. That's still different, than the what Section 23 would approve, but it is an upgrade from what the prior path. So in general, we had a conversation about those 3 states. We're just trying to get all the states equivalent to each other as far as the hours, experience, CPA exam. So there's, like say, the three states. I think it's, like say, if I can see this, California, Colorado, Virgin Islands, their other pathways will expire shortly, and they will be more equivalent to the remaining states. So that was a conversation we had.
Thank you.
Sure.
Mark, is there going to be anything on the Board Effectiveness and Legislative Support Committee from Jennifer?
Ms. Brundage asked me to tell you that they will be meeting next month and that she'll have a more complete report at the October meeting, should she be here.
Okay, and then the State Society Relations Committee, that was going to be Brad.
And Kara's prepared to step in and make a few remarks about that.
Okay.
I'll be brief. Brad first asked me to apologize that he couldn't be here today. He's traveling to attend another meeting today on behalf of the society. Last year, Brad was asked to serve on the NASBA State Society Relations Committee. To this point, I believe there's been 1 in-person meeting held and 2 conference call meetings. The next live meeting will be in September. The committee is comprised of 8 state society CEOs coming from Tennessee, North Carolina, New Jersey, Pennsylvania, California, Texas, Colorado, and Washington. The intent, what it appears of NASBA forming this committee, is to improve relationships between state boards and state societies that, in their view, are strained. The hope is to enhance communication and collaboration between the 2 groups. It's TSCPA's view that we have a very good relationship with this board, and certainly just want to continue that effort. So we may be in a little bit of a different situation than some of the states who are serving on that committee. It's certainly our goal to continue working with this board, working with NASBA and the AICPA for our main goal of just maintaining a state-regulated profession. We hope to continue to work with NASBA on the committee, improve relationships, and with NASBA specifically, and being more engaged with them going forward.
Thank you. I'm not going to go through all these board committee reports just yet, but I'm going to do the executive committee. And Troy, we didn't meet with a committee meeting for law and rules yesterday. Does that mean that there's nothing to discuss today?
Right.
Okay, I'm going to do the executive committee real quick, and then I would like to do the elections unless somebody objects to that. So, executive committee met yesterday. We went over the financial statements. We are projecting a $33,000 surplus this year. We don't really know that for a fact because we don't know what the chargebacks from the state are going to actually be, but our best guess is that we're going to have a $30,000 surplus. That does not consider, Mark, correct me if I'm wrong, the $10 reduction has not gone into effect.
Correct.
In this particular budgetary period. So
Correct.
We should be reducing the fees to the practitioners in the coming year. So that should alleviate some of that surplus. So just to make that note, we did review the travel information. There was some travel by the investigators and by Mark particularly for his NASBA, for what he's committed to on the NASBA committees that he's on. So we did discuss that. And then we had a request, was it from NASBA for the licensee list?
Actually, from the AICPA.
Oh, AICPA, okay. The AICPA had requested a list of our firms, I guess, and contacts at those firms for them to do a practice analysis survey. And this discussion really centered around the fact that probably a lot of that information is public record anyways, but we left it with Mr. Whitaker to ensure that whatever we did, we didn't violate any of the rules and regulations regarding disclosure of any type of information that we shouldn't be disclosing. As long as it was part of the public record, we felt like there was really no harm in doing so. So unless somebody objects to that, that's the path we're on there. And then the discussion of the peer review transparency. Mark, do you want to discuss that just a little bit.
Certainly. You're kind of throwing me off here, Mr. Chairman, taking things out of, sifting through my papers here. Peer review transparency is becoming more and more important, I believe, in the accounting profession due to firm mobility. There are many states who are looking at firm mobility and saying they don't want to participate because there are states like Tennessee that cannot view the peer reviews. They are concerned that we may have some firms that are not doing quality work and we won't know about them. I think that we need to take a good, strong look at the statutes and the rules that we have regarding peer review transparency and perhaps set up a task force with the state society to look at amending those significantly. I will be at the TSCPA Board of Directors, or what is it, Garrett? It's not the Board of Directors, it's the Council. Board of Directors meeting in Barnsley, Georgia, the first part of August, and I intend to broach this idea with them, see where they stand. Brad indicated yesterday that he thought they were on a pathway of least resistance, as he said, to accommodate the board and the board's position on peer review transparency. So the committee wanted to open it up to board discussion today to see where everybody stood. Where are you on the idea of peer review transparency? That requires some board discussion.
I think you mentioned yesterday that we were among fewer than 5 states that had such a privacy rule.
Yes, I think there are only 4 states that have confidentiality laws as strict as ours. And Bill, I didn't get a chance to look that up, but I think it's Ohio, Missouri, and Indiana.
But is there a guideline that is recommended about transparency?
UAA does have language in there regarding peer reviews. So yes, there is guidance available, depending on how
Providing
you want
that
to do
type of information to the board would be helpful.
Sure, I'll be glad to. Unless there's somebody that just really feels strongly that we shouldn't broach this issue at this time.
Does anybody object to pursuing this further, I guess, is the main question for today.
I don't object. I actually think we ought to pursue it further, just from the standpoint of exploring all the pros and cons and what's involved. If we make a decision to change, how do we do that? I mean, I know the Tennessee Society is involved in terms of administering peer reviews, and who are all the parties that need to be involved in this process. But we need to, I guess, find out more information and come back to the board with that information and figure out where we go from there.
And it may be helpful if board staff and the society got together and discussed a little bit further and maybe had a common proposal. Maybe that would help. I don't think anybody's here is against it, but.
Are you saying, let me see if I understand this correctly, are we concerned about how much information is to be made available?
From the peer review process.
From the peer review process?
Right.
Is that, okay.
That's it. Which I think is definitely worth discussing further.
Mm-hmm.
I'd like to know what it's going to be used for and if it's transparent, if there's limitations.
Define limitations, Vic.
Oh, I mean, is it going to be limited to just this board and the peer review oversight committee at TSCPA, or is it going to be some kind of public knowledge?
That is something this board can certainly look at and decide. There are some states that allow the boards and the societies to see the peer reviews and not the public, and of course in other states it's all public information. You are certainly capable of
Any path.
Yes.
Yeah.
Of impacting that decision.
And the purpose then?
You know, from my viewpoint, of course, it's disciplinary. Once you have a peer review that's not good, we need to take some action against the firm. That's my opinion. I don't see how we're protecting the public if we don't.
Mark, you're concerned about firms coming in from out of state, and we want to know what their peer review situation is. Is that what you're
I'm more
talking about?
concerned about the firms in Tennessee.
Well, I know, but in addition to that, though, forgetting about the Tennessee firms, our situation here is to trying to deal with firms coming in from out of state, performing services in Tennessee, us not being able to understand what their peer review situation is.
Yes, that is an issue as well. Isn't it?
That is an issue So if those states were not open to allowing that information to come to us, we would be stuck.
Yes,
We would not be able to find that out.
yes, that's
And
exactly
so
right.
that similar problem would exist with our CPAs in Tennessee going into other states, performing services, and those states being interested in knowing what the peer review situation is for that firm. And the way we're set up now, they can't find out.
So is the recommendation here maybe to, knowing Vic's concerns, and can you work with maybe Brad or Brad's group and make sure that maybe some consensus recommendation is brought back to this board at the next meeting?
Sure,
And we can discuss further at that time.
definitely.
Is everybody in agreement with that? Okay. All right, so that is it for the executive committee report. I would like, does anybody object to us doing the elections right now? No? There's only 9 of us here today, so I'd hate to be gone and leave it to 8 to vote, but I know we had communicated through Mark some of the nominations. However, if people want to just go ahead and renominate now, we could do that. I would like to start, I did nominate Bill Blofus for chairman. Not that I don't think anybody else here can't do that job. I think everybody here is very capable. As Bill has indicated in the past, he is retired, so he has more time than any of us here to deal with the issues of this board. He is local, so he can be available for staff, and those were kind of some of my primary reasons why I chose to nominate Bill for chairman. So I'm just leading that one off, and I will entertain any other nominations for, do y'all want to do them individually? There's 3 positions, so we could do that in that fashion if y'all like.
I would second your nomination, sir.
Okay. I have a second to Bill being chairman. Any discussion? I guess, is there any other nominations? I shouldn't cut that off. Hang on. For chair. Okay, I have a nomination for Bill. I have a second. All those in favor of Bill being chair, please signify by saying aye. Aye. Any opposed? Hearing none, Bill Blofus is hereby elected chairman of the State Board of Accountancy. I guess, is that a 1-year term? Did we do that annually? That's a 1-year term. Okay, so congratulations, Bill, on the chairmanship. We have vice chair. Do I have any nominations for vice chair?
Mr. Chairman, I would like to nominate Casey Stewart to be vice chair.
Mr. Chairman, if I can interject there is a policy in place that you may only serve the position for 2 years, and Mr. Stewart has been the vice chair for 2 years now.
Are you sure that's a policy?
It's policy number 6-3. Board officers, as required by Tennessee Code annotated 62-1-105, shall serve terms that are limited to 2 consecutive years.
That's a policy in here?
Well, it's a policy passed by the board. I mean, you can overcome this by voting on it. But it's not in the rules and regs. No, Bill, it's not that policy. It is board policy.
So a policy of one board can encumber subsequent boards.
Unless you vote to overturn.
Let's don't go there. Let's nominate someone else and make it easy here.
I would like to, I'll go ahead and make a nomination. I think Don Royston for vice chair. I don't know. Don's been on here a long time, has a lot to give, so.
I would second that. If it,
Any other nominations? Okay, hearing none. Any further discussion on that motion? All those in favor signify by saying aye.
Aye.
Any nays? Hearing none, congratulations, Mr. Royston, on vice chair. Okay, and then I have secretary position. I'll entertain any motion or any nominations for secretary.
I'll nominate Henry Hoss for
I
that
have a
position.
nomination for Henry.
Second.
I have a second. Any other nominations? Okay. Hearing none, all those in favor of Henry for secretary, please signify by saying aye.
Aye.
Any opposed? Hearing none, Henry, congratulations to the appointment to the executive committee.
Is there any?
You're in elite status now.
Is there a pay increase for that?
Yeah.
You just work more,
pain-
pay less,
pain
work more.
increase.
It costs more.
It costs more.
And then I guess I'll stay on the executive committee just as a past chairman, so.
Yes.
All right, I appreciate y'all allowing us to do that. Again, I really have enjoyed working with this group, and I think this will be a good group going forward to lead this board. So I think we've accomplished a lot and moved forward on a lot of issues. I know we've been cleaning out this legal backlog that we've had for a couple of years now, so that's good. So anyways, with that, I'd like to turn it back over to Mr. Whitaker. And if I have to leave, Your Honor, I'm going to turn everything over to Mr. Stewart, who will be vice chair or
For the rest of the day?
I'm positive.
What is a quorum?
I think if I recognize a quorum, is that not, I mean, we
No,
have,
what number is a quorum?
well, we have 9 out of 11, so yeah, we've got quorum.
6 is a quorum.
6 is a
Yeah.
quorum?
Yes, ma'am.
Mr. Watkins, if you'd like, you could just step down from the next hearing if you're afraid you're going to have to leave. Again, what happens if somebody leaves in the middle of it? That gets complicated. Mr. Whitaker, how long do you think your next hearing is going to take?
Oh, we got it, we got it, we're gonna make it.
If we can get it done, I mean, if I were to leave and just not vote, does that really harm the case?
Not as long as we still have a quorum when you leave.
Okay, let's just continue. Mr. Whitaker.
He doesn't want to give the gavel up yet. Mr.
Well, no, it's
Stewart.
not that. I'm here to do what I'm supposed to do, so I've got 2 hours.
Mr. Watkins, if I can interrupt for just a minute.
Yes.
If you don't mind, let's go back. I do want to vote to accept the ED report, so we can accept those dates for future meetings.
Okay.
And also, if you'll vote to allow me to sign the final orders in the absence of the chairman.
I got you. Okay.
For the one that you preside.
Okay, can I get a motion to accept the executive director's report?
So move.
Okay, I have a motion, I have a second.
States on, as they normally would have been?
Yes, sir.
Okay, because we altered them last year in order to accommodate your schedule.
Yes, sir.
Okay.
I think that was an exception that one time. Yeah, I got you. Okay, I have a motion, I have a second. Any discussion? Hearing none, all those in favor of accepting the executive director's report signify by saying aye.
Aye.
Any noes? The ayes have it. Can I have a motion to allow Mark to sign the order in my absence?
We'll move.
Second.
I have a motion, I have a
I
second.
want to clarify the orders. It sounds like we may have.
Yeah, what is the technical?
It would be a final order eventually.
Okay.
But I mean, you may have 2.
Oh, for the second one as well.
Right.
That's correct.
That's
Okay.
what I was trying to clarify.
I'm sorry.
So
Okay.
final orders from contested cases held today.
That's perfect.
Thank you.
I have a motion
So moved.
and a second by Mr. Eldridge. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Okay. Any nays? Okay, the ayes have it.
All right, members of the board, as we announced this morning, one of the cases this morning was continued, so there is only one more case on the July 25th, 2014 docket. That is the case of the Department of Commerce and Insurance versus Lisa J. McMurrin.
McMurrin, I believe.
Okay, and that's spelled McMurrain. The docket number is 12.19-124932A. Again, as I introduced myself this morning, I'm Mary Collier, the administrative judge assigned to sit with you all in today's hearings. Is there anyone here on behalf of Lisa J. McMurrin, or is Ms. McMurrin here? It does not appear she is here. Does the board have copies of the notice of charges on the iPads?
Yes, Your Honor.
All right, members of the board, if you'd like, you may pull up that second notice of hearing that should be on your iPads. It's for the Lisa J. McMurrin case. There are multiple documents in this file, most of which are return mail. There's that first document you're looking at now, the notice of hearing. The second document is the order I issued on June the 20th of 2014, and Mr. Whitaker had provided my office with 6 addresses for Ms. McMurrin, so we sent my order to all 6 addresses. So the third document in the record is the copy of the order that was sent to her Rosewood Lane address in Oklahoma City. It was returned not deliverable as addressed, unable to forward, so that's technical record entry number 3. Technical record entry number 4 is the copy of my June 20th of 2014 order that was sent to the West Country Club Drive, Oklahoma City address. It was returned to sender, attempted, not known, unable to forward. The 5th document in the technical record is the copy of my June 20th, 2014 order that was sent to the Pelican Lane address in Coppell, Texas. It was handwritten on addressee, not at this address, and then the post office put a stamp on it that says return to sender, not deliverable as addressed, unable to forward. 6th document in the record is a copy of my June 20th, 2014 order that was sent to Ms. McMurrin at her Kent Drive address in Oklahoma City, Oklahoma. It was also handwritten on not at this address, and then the post office put a stamp, return to sender, attempted, not known, unable to forward. And then the 7th document in the technical record is a state's witness and exhibit list that was filed on July the 17th of 2014. Mr. Whitaker, do you have proof of service of Ms. McMurrin in this case of the notice of hearing?
Your Honor, we do not. As with the last matter, we'll be presenting evidence of our attempts at service for Ms. McMurrin, and then the conclusion of that proof, the state will have a motion.
All right. Who would you like to call to present that evidence?
State calls Jenica Smith.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Your Honor.
Thank you.
Ms. Smith, can you please state your name and position for the record?
My name is Jenica Smith. I'm a paralegal for Commerce and Insurance Regulatory Boards
And how long have you been so employed?
since February 2014.
And are you the lead paralegal assigned to work on this matter for the state in preparation for today's formal hearing?
Yes, sir.
And have you reviewed Ms. McMurrin's board complaint file prior to your testimony today?
Yes, sir.
And based on your review of that file, what date was the notice of hearing and charges filed in this matter?
June 10th, 2014.
And by what methods did the state attempt to serve the respondent with the notice of hearing and charges in this matter?
Certified mail, regular U.S. mail, and FedEx.
And did you also attempt to contact the respondent by phone to advise her of the notice of hearing and charges and today's formal hearing?
Yes, sir.
And how did you decide where and how to attempt to notify Ms. McMurrin of today's hearing?
We did the board's records, internet searches, and a Westlaw Clear search.
Okay, and based on your review of Ms. McMurrin's complaint file, is 6300 Heritage Court, Edmond, Oklahoma 73003 the respondent's address of record with the board?
Yes, that's listed in the database.
Okay. And did you run any sort of searches or reports to attempt to track down Ms. McMurrin?
Yes, as stated before, I ran a Westlaw Clear search on June 17th, 2014.
And can you explain again for the record what a clear search is?
It's a service provided by Westlaw that compilates all public records for a specific person. We search it by name, last known address, social security number, date of birth if available.
And does the Board of Accountancy maintain social security numbers for CPAs licensed to practice in Tennessee?
Yes, this respondent's social security number was in our database.
Is that the social security number that you used in your clear search to attempt to track down the respondent?
Yes.
Okay. When you ran your clear search, about how many mailing addresses came up that could be related to Ms. McMurrin's name and social?
I believe there were 24.
Okay. And copies of the notice of hearing and charges were not sent to all of those addresses, were they?
Not all of them.
Okay. And for what reason were they not sent to all the addresses?
These addresses dated back to 1995, so they kind of predated the events alleged in the notice of hearing and charges.
Okay. And after excluding the older and otherwise potentially not relevant addresses, how many addresses were left?
6.
Okay. And were copies of the notice of hearing and charges sent to all 6 addresses remaining by certified U.S. mail?
Yes.
Okay. And are those the same addresses which appear in the certificate of service section of the notice of hearing and charges?
5 of those addresses were, and then there was an additional address in the certificate of service.
Okay. And what date were the copies of the notice of hearing and charges sent to the respondent by certified U.S. mail?
The ones on the certificate of service were sent on June 10th, and that included the 855 Pelican Lane address that did not show up on the clear report, and then an additional service via FedEx certified mail and regular mail was June 23rd.
Okay. And based on your review of Ms. McMurrin's complaint file, does it appear that the 2814 West Country Club Drive, Oklahoma City, Oklahoma 73116 address is the respondent's last known address of record with the Oklahoma Board of Accountancy?
Yes, that was the address on their record.
Okay. And of the notices of hearing and charges that were sent to the respondent in this matter, were any of those notices successfully delivered to anyone?
Yes, the 855 Pelican Lane, Coppell, Texas, 75019 was delivered on June 13th, 2014.
Okay. And do you know who signed for that copy of the notice of hearing and charges?
Her name was Lisa McMurrin Knowlton.
And can you spell Knowlton for the record, please?
Knowlton.
Okay. And is Lisa McMurrin Knowlton, in fact, the respondent in this matter?
No, that is not the respondent in this matter.
To the best of your knowledge, based on your review of the complaint file, who, in fact, is Lisa McMurrin Knowlton?
It appears from the notes in the complaint file that she is actually the respondent's ex-sister-in-law and not the respondent.
Okay. So, to summarize, to the best of your knowledge, were any of the 6 copies of the notice of hearing and charges actually sent and delivered to the respondent in this matter?
No.
Okay. And subsequent to the initial mailings on June the 10th, were there any other addresses to which the notice of hearing and charges in this matter were sent to try to serve the respondent?
Yes, the Westlaw Clear report came up with an address as current as March 23rd, 2014, and that address was 200 South Oklahoma Avenue, 205, Oklahoma City, Oklahoma, 73104. We sent that via FedEx, via certified mail, and via regular U.S. mail on June 23rd, 2014.
And was that FedEx mailing next day delivery?
Yes, Federal Express next day delivery, tracking number 800561998630.
Okay. At this time, I'd like to show you a set of documents and ask you to identify them for the record.
What date did you say you sent that to the 7th address?
That was June 23rd, 2014, via next day delivery, certified mail, and regular U.S. mail. This first document handed to me is the letter dated June 23rd via Federal Express next day delivery to Lisa McMurrin at the 200 South Oklahoma Avenue, number 205 address, signed by Christopher Whitaker, stating that it enclosed the notice of hearing and charges filed on June 10th, and advising of this hearing today. Attached to it is the FedEx Air bill showing the tracking number. And then also is the June 23rd, 2014 letter sent via certified mail and first class U.S. mail with its tracking number on it. It is also a letter from Chris Whitaker, including the notice of hearing and charges that was filed on June 10th and notifying Ms. McMurrin of the hearing. Additionally, handed to me is a copy of the envelope for the 200 South Oklahoma Avenue, Suite 205. It's the certified mail. It's stated return to sender, and it's marked as unclaimed. And then behind it is the domestic returned receipt and the certified receipt.
And Ms. Smith, to the best of your knowledge, were either of these mailings, the certified U.S. mail or FedEx next day delivery mail, successfully delivered to the respondent?
No, not the certified or the Federal Express. They were both returned to our office.
Okay, and are these documents true and correct copies of the documents contained in Ms. McMurrin's complaint file in this matter?
Yes.
And are these documents maintained in the regular course of business of the Accountancy Board and in Ms. McMurrin's complaint file?
Yes.
Your Honor, at this time I request that the set of documents as testified to by Ms. Smith be entered as Collective Exhibit 1.
Thank you, Mr. Whitaker. I'm going to enter as Exhibit Number 1 the document that's stapled together, which has the June 23rd, 2014 letter from you to Ms. McMurrin at this new address, the 200 South Oklahoma Avenue, Suite 205, Oklahoma City, Oklahoma, 73104 address, as Exhibit Number 1. That has the FedEx information and the U.S. mail. And you may pass copies of that to the board. I'm going to enter separately as Exhibit Number 2 the actual envelope. And members of the board, I will pass to you the envelope itself, where you can see that there were multiple attempts. They've actually apparently made a copy too, so that's good. But I'll send you the original too. They've made multiple attempts by the post office to deliver this, and it has been marked by the post office as unclaimed.
Ms. Smith, let's turn now to your efforts to notify the respondent of today's formal hearing by telephone. The clear search referenced earlier in your testimony, approximately how many phone numbers came up as potentially related to the respondent?
About 14.
Okay. And did you attempt to call the respondent at all of those phone numbers?
No, we excluded a few of those because they were older. They predated the events.
Okay. And after excluding older and otherwise potentially irrelevant phone numbers, how many phone numbers were left?
12.
Okay. And did you place calls to all of those numbers?
Yes.
And did you attempt to place those calls at various points on June 23rd, 24th, and 25th?
Yes.
And were all of those numbers located in Oklahoma City or nearby areas?
Yes, they were all 405 area codes.
Okay. And of those phone numbers that you called attempting to reach the respondent, how many of them were non-functional or fax numbers?
There were 4 of them.
Okay. And at how many of those phone numbers did you speak to a live person?
5 of them.
And of those 5 phone numbers where you spoke to a live person, did any of them mention knowing the respondent in any way?
There was one phone number, 405-843-8188. I called it at 2:44 p.m. Central Time on June 23rd. The lady who I spoke with identified herself as Jill. She stated that the company's name was Churchill Brown. I requested to speak with Lisa J. McMurrin and was advised that she's no longer with the company. I asked if she knew when she left the firm, and she stated that it had been over a year. She didn't say that she knew her personally, but she was aware of who Lisa J. McMurrin was.
Okay. And did this lady from Churchill Brown have any way, to the best of your knowledge, to reach Miss Lisa J. McMurrin?
No, she did not.
Okay. And it, again, of the phone numbers listed on the clear report that you testified to earlier, how many did you reach a voicemail recording?
5.
Okay. And did any of those voicemail greetings at any of those phone numbers contain any indication that they belonged to Miss McMurrin?
No, they were all very generic voicemail recordings. Basically only stating the phone number you have reached, and they listed the phone number.
Okay. And on those 5 phone numbers, how many times did you attempt to call each number?
Of 4 of the 5 numbers, I called them 3 times on the 23rd, 24th, and 25th. On the 405-843-5895, I called it twice, once on the 23rd and on the 24th. I reached somebody who stated that this was not the respondent's phone number.
Okay. And of the phone numbers where you did reach a voicemail, did you leave voicemails on all of those phone numbers?
Yes, every time.
Okay. And what was the substance of the voicemails you left on those phone numbers?
I left messages stating that I was trying to reach Lisa J. McMurrin, and I stated my name and that I'm a paralegal with the Tennessee Department of Commerce and Insurance. I stated that I was calling regarding the hearing set for July 25th, 2014 in front of the Board of Accountancy. I stated that I was calling to verify if she received the notice of hearing and charges that was sent to multiple addresses via certified mail on June 10th. I left my direct extension and requested that she call me back to verify receipt of the notice of hearing and charges, or to call me back and notify me that this was not the correct phone number for Ms. McMurrin.
Okay. And in response to the voicemails that you left, did the respondent, Lisa J. McMurrin, ever contact you back at any time?
No, sir.
Okay. And during the clear search you performed and any other research you performed for this case, were you ever able to locate an email address for this respondent?
No, sir.
And if you had been able to locate an email address, would you have also sent the notice of hearing and charges via email to try to reach her?
Yes, sir.
Thank you, Ms. Smith. I have no further questions at this time.
Thank you, Ms. Whitaker. Members of the board, do any of you have questions for Ms. Smith? Thank you, Ms. Smith.
Your Honor, this concludes the state's proof of attempted service, and the state would have a motion at this time.
Go ahead.
Your Honor, the state hereby moves that the respondent, Lisa J. McMurrin, be declared in default pursuant to TCA 4-5-309 Secretary of State Rules 1360-04-01-.06 and -.15, and the case of Johnson versus Tennessee Board of Nursing, 2007 Westlaw 624353. And based on the evidence presented and the testimony presented, we would request that the board find Ms. McMurrin in default and allow the state to proceed uncontested in this matter. Thank you.
Thank you, Mr. Whitaker. Members of the board, based upon the testimony of Ms. Smith and the two exhibits that were entered into evidence during her testimony, I find that the state has complied with the rules applicable to this case with regard to service and attempts of service. And the rule that I cited you all to earlier today, 1360-04-01-.06, applies in this case as well. And I find that the state, based upon their multiple efforts to locate Ms. McMurrin, made the requisite attempts at multiple types of service, and unfortunately, that seventh address they had came back unclaimed. But under these rules, as well as the Tennessee Rules of Civil Procedure, when something comes back unclaimed as that nature, I think the state has made sufficient attempts at serving Ms. McMurrin. So based upon that, it's my opinion that the service attempts are sufficient and proper in this case. It's your job then to determine whether or not you want to hold Ms. McMurrin in default and proceed with an uncontested case. Tennessee Code Annotated 4-5-309A defines default as follows. If a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case, the administrative judge or hearing officer hearing the case alone, or agency sitting with the administrative judge or hearing officer, may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having due regard for the interests of justice and the orderly and prompt conduct of the proceedings. So at this time, Mr. Chairman, I would turn it over to you and the board members to determine if you would like to hold Ms. McMurrin in default based upon her failure to appear at the hearing today after the multiple attempts at service by the state of Ms. McMurrin.
I'll entertain a motion.
Chairman, I'd make a motion that we find the Ms. McMurray in default for not showing up today, and that we have proven service.
Second. Okay, I have a motion by Mr. Royston. I have a second by Ms. Spiceland. Any discussion? Hearing none, let's do a roll call vote. Can we start with Mr. Hoss this time?
Mr. Hoss votes yes.
Charlene Spiceland, yes.
On Royston, yes.
Troy Brewer, yes.
Bill Bluffus, yes.
Trey Watkins, yes.
Casey Stewart, yes.
Stephen Eldridge, yes.
Vic Alexander, yes.
Okay, this board finds that Ms. McMurrin is in default and that we could proceed with the case today.
Thank you, members of the board. Mr. Whitaker, the board has found Ms. McMurrin in default, and so at this time, would you like to make an opening statement with regard to the proof of the case?
Just very briefly, Your Honor. Members of the board, my name is Chris Whitaker, and I'm counsel for the state in this matter. The state is bringing this formal hearing against the respondent, Lisa J. McMurrin, for various alleged violations of the Tennessee Accountancy Act and the rules promulgated thereunder. At the conclusion of its proof, the state expects to prove that the respondent, Lisa McMurrin, admitted in a consent order signed with the Oklahoma Board of Accountancy to committing multiple felony crimes, including financial crimes, that the respondent, Lisa J. McMurrin, had her Oklahoma license revoked due to her guilty plea to multiple criminal felony counts, and the consent order that she signed Oklahoma Board as a result of that. And finally, that the respondent failed to timely notify the Tennessee Board of the revocation of her Oklahoma license as required by Tennessee law. At the conclusion of the state's proof, the state will have a prayer for relief, which we will reserve at this time. Thank you.
Thank you, Mr. Whitaker. And who would you like to call as your first witness?
State calls Mark Crocker.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Crocker, will you please state your name and position for the record?
My name is Mark H. Crocker, and I'm the Executive Director of the Tennessee State Board of Accountancy
And how long have you been so employed?
since October of 2007.
Are you also the custodian of records for the board?
Yes, sir, I am.
And prior to your testimony today, have you reviewed Ms. McMurrin's licensing and complaint files?
Yes, sir, I have.
Has the respondent in this matter ever held a Tennessee CPA license?
Yes, sir, she has.
And what is that license number?
That license number is 10350.
As of the date of this hearing, is Ms. McMurrin's Tennessee CPA license current and in good standing?
No, sir, it is not.
Is her Tennessee CPA license currently expired?
Yes, sir, it is.
And when did that license expire?
That license expired December 31st, 2000.
Absent disciplinary action by the board in today's formal hearing against Ms. McMurrin's Tennessee CPA license, could she theoretically pay all past due fees, meet other applicable license requirements, and reinstate her Tennessee CPA license to good standing?
Yes, sir, she could.
And how did Ms. McMurrin first come to your attention in this matter?
We received notice from the Oklahoma Board of Accountancy that Ms. McMurrin's Oklahoma CPA license had been revoked by consent order due to her guilty plea to multiple felonies.
Okay, and on that basis, did the board in fact open a complaint against Ms. McMurrin?
Yes, sir, we did.
Okay, I'd like to show you a set of documents and ask you to identify them for the record.
This appears to be the complaint that we opened against Ms. McMurrin after her license in Oklahoma had been revoked.
And what date was that complaint opened?
This complaint was opened February the 22nd, 2013.
And is this document maintained and kept in the regular and ordinary course of business of the Tennessee State Board of Accountancy?
Yes, sir, it is.
Is it also maintained and so kept in Ms. McMurrin's complaint file in this matter?
Yes, sir, it is.
Your Honor, at this time I move that the complaint against the respondent, Lisa J. McMurrin, dated February 22nd, 2013, be entered into evidence as Collective Exhibit 3.
The complaint dated February 22nd of 2013 will be entered into evidence as Exhibit Number 3, and you may pass copies to the board. And members of the board, it was pre-marked as Exhibit Number 2, so if you all would scribble out the 2 and make it a 3, please, on your copies. 2 was the envelope that was submitted as part of the proof of service, which if one of y'all would pass it back to me, that would be helpful too.
Mr. Crocker, what is the allegation in that complaint against Ms. McMurrin?
That her Oklahoma CPA license had been revoked and that she failed to notify the Tennessee Board of that revocation in writing.
Okay, and did the board transmit a copy of this complaint to Ms. McMurrin's last known address of record with the board via certified U.S. mail?
Yes, sir, we did.
And is that address 6300 Heritage Court, Edmond, Oklahoma 73003?
Yes, sir, it is.
And did Ms. McMurrin ever respond to the initial mailing to her of the complaint in any way?
No, sir, not at all.
And is it a violation of the Accountancy Act and the rules promulgated thereunder for a Tennessee licensed CPA to fail to respond to a complaint in a timely manner?
Yes, sir, it is.
And does Ms. McMurrin's failure to so respond constitute one or more violations of the Accountancy Act and rules?
Yes, sir, it does.
And in your opinion, the board is within its authority to impose discipline against Ms. McMurrin on that basis?
Yes, sir, most definitely.
I'd like to show you another set of documents and ask you to identify them for the record as well.
This appears to be a copy of the consent order from the Oklahoma Board signed by Ms. McMurrin in which she agreed to the revocation and admitted to all acts alleged.
Okay, and for the record, can you please describe the stamp in the upper right-hand corner of the first page of the set of documents in front of you?
This is a stamp that says, "I hereby certify that this is a true and correct copy of the original document dated the 25th of February 2014, signed by Randy Ross, who's the Executive Director of the Oklahoma Accountancy Board."
Okay, and are these documents also maintained and kept in the regular and ordinary course of business of the Tennessee Accountancy Board?
Yes, sir, they are.
And are they also kept and maintained in Ms. McMurrin's complaint file in this matter?
Yes, sir, they are.
Your Honor, pursuant to Tennessee Rule of Evidence 8036 relative to business records and Tennessee Rule of Evidence 902 sub 1 relative to self-authenticating documents, request that the revocation consent order from the Oklahoma Board against Lisa J. McMurrin be entered as Collective Exhibit 4.
The consent order filed with the Oklahoma Accountancy Board on November 20th of 2009 will be marked and entered into evidence as Exhibit Number 4. You may pass copies to the board. Members of the board, this was pre-marked as Exhibit Number 3. So on your copies, if you would change that marking to Exhibit Number 4, please.
Crocker, after reviewing the documents submitted to the Tennessee Board by the Oklahoma Board, could you determine why Ms. McMurrin's Oklahoma CPA license was revoked?
Well, among other things, in 2009, they assessed a civil penalty of $5,000 plus costs and revoked her license because she had pleaded guilty to 8 counts of 8 felony counts, including embezzlement, misuse of a client credit card, and obtaining money under false pretenses.
Directing your attention to page 4 of the consent order you have in front of you and paragraph 12, can you please read that aloud for the record?
Paragraph number 12. On respondent's individual registrant reporting form due July 31st, 2007, respondent acknowledged working for Lux Travel, 2814 Country Club Drive, Oklahoma City, Oklahoma, 73116. Respondent filed her individual registrant reporting form electronically on August 28, 2007, and paid her $200 registration fee via Chase credit card ending in 3050.
Based on your review of the file in this consent order, does that Chase Visa credit card ending in 3050 belong to Ms. McMurrin?
I don't believe so.
To the best of your knowledge, is that in fact a credit card number for one of her clients for which she pled guilty to criminal charges?
Yes.
And so it's your testimony that it appears that Ms. McMurrin misused a client credit card to pay her professional registration fees with the Oklahoma Accountancy Board?
Yes, sir.
Okay. Does the conduct admitted to by Ms. McMurrin in her Oklahoma Board consent order constitute one or more violations of the accountancy statute and rules in Tennessee?
Yes, Ms. McMurrin's conduct, as admitted in her Oklahoma consent order, constitutes dishonesty, fraud, misrepresentation, conviction of one or more felonies, and committing acts that reflect adversely on a CPA's fitness, all of which are violations of Tennessee's laws and rules.
In your opinion, does this board have the authority to discipline Ms. McMurrin's Tennessee CPA license on that basis?
Most certainly they do.
And if a CPA licensed in Tennessee has his or her CPA license revoked in another state, does that constitute grounds for discipline against that CPA's Tennessee license?
Most definitely, yes, sir.
And is a CPA is licensed in Tennessee and has his or her license revoked in another state, are they also required to notify this board in writing of such revocation?
Within 30 days, yes, sir.
And to the best of your knowledge, did Ms. McMurrin ever so notify the Tennessee board either in a timely manner or at any time thereafter?
No, sir, she did not.
And does Ms. McMurrin's failure to timely notify the board in writing of the revocation of her Oklahoma CPA license constitute one or more violations of the Tennessee law and rules relative to accountants?
Yes, sir, it does.
And that is also grounds to impose discipline on Ms. McMurrin's license, is it not?
Yes, sir, it is.
Thank you, Mr. Crocker. I have no further questions.
Thank you, Mr. Whitaker. Mr. Chairman, members of the board, do any of you have questions for Mr. Crocker?
One question, Mark. Did you say that the Tennessee license had been expired since 2000? Would we not have something to automatically revoke that license if something has been expired for that period of time?
No, sir, we do not.
Do we look at expired licenses that have been out there for more than 4 years, perhaps? I mean, are they on our litigation report or any? We don't do any. Do we do anything with those expired licenses?
I've been trying to notify them, Mr. Watkins, but we don't have any set procedure for doing that, no. We notify them the minute they go expired, but we've just been doing that for the past 5 years.
We don't really have an aging tracking tool or anything like that.
I can pull them up for you if you want to know who's expired. Yes, we can do that.
Seems to me after 13 years, this license should have been revoked. That's my point, I guess.
Any other questions for Mr. Crocker?
Crocker, why would that not have shown up on our, since we've been getting in the last couple of years, the professional privilege tax? She obviously hasn't paid that either. Why wouldn't that have shown up on our radar?
Because she's not assessed professional privilege tax on an expired license. They only assess on active licenses.
Thank you.
Any other questions for Mr. Crocker? Whitaker, do you have any other questions for Mr. Crocker?
I do not, Your Honor.
Thank you, Mr. Crocker.
Your Honor.
Your Honor, that concludes the state's proof in this matter, and with Your Honor's permission, I'd like to make a brief closing statement and then turn it over to the board.
Thank you. Go ahead.
Members of the board, thank you for your time and attention in this matter. The state respectfully submits that at the conclusion of its proof today, it has proven that the respondent, Lisa J. McMurrin, has engaged in some of the most egregious conduct that a CPA could engage in, namely misuse of client funds, misuse of client credit cards, obtaining money under false pretenses, which strikes at the very heart of the trust of CPAs and the accounting profession in general. Therefore, the state is seeking what it believes the maximum penalties are allowable under Tennessee law in this matter. The state's prayer for relief in this matter for Ms. McMurrin's violations will be a civil penalty in the amount of $5,000, which does mirror and reflect what the Oklahoma board assessed. A 5-year license revocation, which is the maximum that the board may revoke a license for until Ms. McMurrin may reapply, provided the board is under no obligation to reinstate the license after that time. And additionally, that if Ms. McMurrin ever does show back up and attempt to reinstate her Tennessee CPA license, that she be required to appear in person before this board, distance from here notwithstanding, in order to explain the matters in Oklahoma and to answer any questions the board may have. Closing statement, Your Honor.
Thank you, Mr. Whitaker. Members of the board, you have now heard the proof in the case of the Tennessee Department of Commerce and Insurance versus Lisa J. McMurrin, which is docket number 12.19-124932A. It is now my duty to charge you as to the law you must follow in reaching your decision. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law, specifically your statutes, rules, and regulations, and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondent has violated certain of the state of Tennessee's applicable statutes and rules. It is the state's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence presented. You must limit your inquiry into the violations of rules and statutes to those that were specifically alleged in the state's notice of hearing and charges, which is the document you were given on your iPads at the beginning of this hearing. And you must base your determination solely on the evidence presented to you during this hearing. The evidence consists of the testimony given by the witnesses during the hearing and the exhibits introduced into evidence, which you may review during your deliberations. Statements and arguments by the attorney in the case and the documents contained in the technical record, such as the notice of charges, and any proposed order that Mr. Whitaker should give you, are not considered evidence in this case. You may use these arguments and documents to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and a determination that those documents and arguments accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. You should always keep in mind that the state bears the burden of proving the charges. The respondent does not have the burden of proving that she is innocent. Your final order should contain 4 specific sections. Number 1, findings of fact. Number 2, conclusions of law. Number 3, a decision regarding what disciplinary action shall be taken, if any. And if disciplinary action is taken, you shall specify what that is. And number 4, the policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony and other evidence presented during the hearing. You must then give that testimony or documentary evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state of Tennessee statutes as alleged in the notice of charges. And if so, you must state those determinations in the conclusions of law portion of your order. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions of law. Your conclusions of law should make appropriate specific references to your findings of facts in your order in order to articulate linkages and connections between these 2 sections of your order. If you decide that there has been a violation of any state statute or rule, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary actions they take. However, this does not mean that you may make arbitrary and capricious disciplinary actions. Instead, disciplinary actions must be based on fairness and reason. Finally, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason is your statement explaining to the public why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your deliberations must be in public before all parties. If you need assistance with the law or the structure of your order, I am available to assist you. If you have any additional questions about the facts that were presented, you may, by majority vote, reopen the proof and hear further testimony from the witness and/or argument from counsel. And Mr. Whitaker, do you have a proposed order in this case?
Yes, Your Honor, I do.
All right, if you would pass that up, please. Members of the board, I will enter the proposed order into the record as technical record entry number 8, so it will be included in the file should this be appealed. This time, Mr. Chairman, I will turn the case over to you all for deliberations and the formulation of your order.
We'll give everybody a minute to look through the proposed findings of fact, conclusions of law.
I asked a question of the judge.
Yes.
You said 4 things: finding of fact, conclusions of the law. What was number 3?
Findings of fact, conclusions of law, the disciplinary action, if any, and then the policy reason.
Can I ask a question? Connor, what was the reference for this document?
It's going to be technical record entry number 8.
Everyone had sufficient time to review the document? First, we have to establish the finding of fact. I'll entertain a motion.
I make a motion that we accept the allegations of fact, numbers 3 through 21, on pages 2 through 8 in the proposed findings of fact and conclusions of law, technical record entry number 8.
I have a motion. Do I have a second?
Second.
I have a second by Mr. Eldridge. Any discussion?
Started with number 1. I'm sorry, numbers, yes, you're right. It was numbers 1 through 21. Thanks.
1 through 20.
Right.
Okay. So I've got a revised motion here by Dr. Spiceland, so
I'll second it.
you'll have a second on that.
Yes.
Okay. Any discussion? Hearing none.
I think these findings of fact that they point out here are very, very clear to us as to what the circumstances were.
Absolutely. Most of these were in the consent order to begin with.
Right.
With
Exactly.
State of Oklahoma. I guess there's kind of 2 parts: the act's discreditable, and then the failure to notify this board of those issues. Okay. All those in favor of the motion, let's do a roll call vote. I'll start with Mr. Haas over here if you're in favor of that motion.
Henry Haas, I vote yes.
Charlene Spiceland, yes.
Don Royston, yes.
Troy Brewer, yes.
Bill Bloffish, yes.
Trey Watkins, yes.
Casey Stewart, yes.
Stephen Eldridge, yes.
Vic Alexander, yes.
Okay, the motion carries with the vote, and the findings of fact are adopted. The next consideration, the conclusions of law.
I move that we accept the conclusions of law, numbers 1 through 10, on pages 7 through 11, and the proposed findings of fact and conclusions of law, technical record entry number 8.
Are you looking at the
I think we're on the
proposed
wrong
order or
document.
the notice of hearing?
I think you may be on the wrong
Oh,
document.
notice of here. I am on the wrong page.
Page
Pages
8.
8 through.
So which document are you referring to, ma'am?
I'm referring to the proposed, this one.
The proposed order?
findings
Okay.
Of fact and conclusions of law, which is technical record entry number 8, right?
You had just cited to page 7, and there are no conclusions of law on page 7 of that document, and that's
I
what I
meant-
was trying to
I'm
make sure we're
sorry.
all looking at the same document.
Meant to say 8.
Pages 8 through
13.
13, and those are 1 through 9.
10.
Or 10, did I
10.
miss one? Sorry, I stopped short. So I've got the motion from Dr. Spiceland. Do I have a second?
Second.
I have a second by Mr. Eldridge. Any further discussion? Hearing none, all those in favor of the motion, please start with a roll call with Mr. Hoss.
Henry Haas, yes.
Charlene Spiceland, yes.
Royston, yes. Roy Brewer, yes.
Bill Bloffish, yes.
Trey Watkins, yes.
Casey Stewart, yes.
Stephen Eldridge, yes.
Dick Alexander, yes.
The motion carries. The conclusions of law have been entered in. We have to consider the disciplinary, and at Your Honor's request that we be a little more specific in this front as we assess the civil and administrative costs, that we are specific with these, maybe even by, how many were there? Count one. There are 3 here, so we might want to consider each 3 of these separately maybe and state perhaps the penalty if you agree, or if you don't agree with the penalty, we can make it whatever we want, but, or within the guidelines. But let's maybe take these one by one, and maybe that'll alleviate some of the concerns we had before. I'll take a motion on the disciplinary portion of this case, and I would recommend that we start with this count 1.
Move that we impose a civil penalty in the amount of $3,000 against the respondent
That based on count 1.
based on count 1, and that we revoke the respondent's CPA license, and that the board, and that we require that the respondent appear in person before the board as a condition of reinstatement, should she petition the board for reinstatement of her Tennessee CPA license in the future.
Second the motion.
Get that? The motion?
You read the rest of it?
No, I'm good. Okay, I have a motion, I have a second. Any discussion on that count 1 penalty? Hearing none, all in favor of the penalty outlined under count 1, please signify by roll call, starting with Mr. Alexander.
Dick Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Trey Watkins, yes.
Bill Bloffish, yes.
Roy Brewer, yes.
Don Royston, yes.
Charlene Spiceland, yes.
Henry Haas, yes.
Okay. Further disciplinary action, might want to consider count 2 as outlined in this document.
I move that in response to count 2, the board impose a civil penalty in the amount of $1,000 against the respondent and revoke the respondent's Tennessee CPA license.
Second the motion.
You already revoked the license with the first one.
Yeah.
We want to make sure it happens.
All right, so does that present any problems to you, Your Honor, that it's in there twice?
No,
Okay. Okay,
you
I have a
revoked it
motion.
many times.
Okay. A motion, I have a second. Any discussion on the penalties outlined under count 2? Hearing no discussion, let's start with a roll call vote. Mr. Alexander, if you would start.
Dick Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Ray Watkins, yes.
Bill Bluffus, yes.
Troy Brewer, yes. Don Royston, yes.
Charlie Spiceland, yes.
Henry House, yes.
Okay, the motion carries. The penalties on count 2 are accepted. Count 3, I'll entertain any motion on the penalties considered under count 3.
Move that based on the violations of count 3, that the board impose a civil penalty in the amount of $1,000 against the respondent. Do we need to revoke it again? I'm going to read it and revoke the respondent's Tennessee CPA license.
Or it should be clear.
Second.
Okay, I have a motion by Mr. Eldridge. I have a second by Dr. Spiceland. Any discussion? Hearing none, all those in favor, let's start with the roll call, starting with Mr. Alexander.
Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Ray Watkins, yes.
Bill Bluffus, yes.
Brewer, yes. Don Royston, yes.
Charlie Spiceland, yes.
Henry House, yes.
Okay, the motion carries unanimously, so the penalties assessed under count 3 are accepted.
Mr. Chairman,
Yes, ma'am.
I believe in his closing argument, and then in what's the last paragraph of page 15, Mr. Whitaker is asking that you all revoke the license for a period of 5 years. But in counts 1, 2, and 3 that you've just adopted, I don't see that 5-year language. I might have just missed it. But
I don't think you
since you
did.
have now revoked it 3 times, I would just recommend you clarify that the length of time you'd like it to be revoked.
Can I add one thing there? My understanding is that the 5 years is by law or by statute. Is that correct? My impression from what Mr. Whitaker said was that we can't revoke it for more than 5 years.
Correct. That's the maximum
Well,
you can
you
do.
can't
But what I'm saying is, in your discussions, y'all haven't said how long you want it revoked for. If you want to go with the maximum, I'm just recommending you all
We could just
clarify that
You
you
just
like
want to do
that.
it a separate motion maybe that clarifies.
Yeah.
I move that we revoke the respondent's license for 5 years.
Second.
I have a motion, I have a second. Any discussion? And did we state that we want that person, I think we wanted that person before they came back up to respond in person, I guess. Does that matter that we have that in?
Yeah, that was in count 1.
That wasn't one, okay.
Yes, sir.
Gotcha, okay. So I'll stay out of it, okay. So I have a motion, I have a second. Any more discussion? Hearing none, all those in favor, please signify by roll call vote, starting with Mr. Alexander.
Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Trey Watkins, yes.
Bill Bluffus, yes.
Troy Brewer, yes. Don Royston, yes.
Charlie Spiceland, yes.
Henry House, yes.
Okay, the motion carries, and we have clarified the revocation period of the license.
And then one other issue that I would clarify, and again, I'm not trying to criticize you all. I didn't draft the order.
Feel free, I'm used to it.
Mr. Whitaker has included in counts 1, 2, and 3 the assessment of investigatory and hearing costs, but you all have had no discussion of that.
Okay.
So I would recommend you just have a quick
Right.
discussion and vote if you want to assess cost, and just make sure the record's clear that you are intending to do so.
You don't have a number assigned to that. That's
He
just
sort of incorporated it in there, but you all
Okay.
didn't discuss it in your discussions.
Okay, I will,
You can assess a specific amount if you'd like. Is that what your question was?
I didn't know if he had actually specified. Haven't we done that in the past? I'm trying to remember.
They don't know the total cost when they
Until
come
you
to the
get your
hearing,
bills
because
and
again, it involves the investigatory costs involve also the court reporter who's sitting next to me. It involves my office's
Right, right.
cost. So they usually file with my office after the final order affidavit of cost, and they serve that on the respondent, letting the respondent know X amount.
Yep.
But a lot of boards do say, we assess costs not to exceed X amount, so if you wanted to set a cap on that, you're allowed to, but that's your discretion.
Okay. I'll entertain a motion on the costs.
I move that we assess administrative and investigatory cost in this matter.
Second.
I have a motion, I have a second. Any discussion? Hearing none, all those in favor, please start roll call vote with Mr. Alexander.
Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Trey Watkins, yes.
Bill Bluffus, yes.
Troy Brewer, yes. Don Royston, yes.
Charlie Spiceland, yes.
Henry House, yes.
Motion carries to assess administrative and investigatory costs. So that is done. So now you need my policy reason? Okay. The primary purpose of this board is to protect the public. In this particular case, the public was harmed by Ms. McMurrin's actions. And in addition, she did not comply with the rules and regulations of the state of Tennessee, accountancy laws and rules. So for that reason, we have assessed the penalties that we have assessed and found her, for the reasons that we have trying to figure my words out, sorry, that we assessed the penalties for the reason that we did is because she was in violation of the rules and regulations and that she caused harm to the public. So I guess that's a motion.
Second.
Okay, any discussion? Hearing none, all those in favor signify by roll call vote, starting with Mr. Alexander.
Alexander, yes.
Stephen Eldridge, yes.
Casey Stewart, yes.
Trey Watkins, yes.
Bill Bluffus, yes.
Corey Brewer, yes. Don Royston, yes.
Charlie Spiceland, yes.
Henry House, yes.
Motion carries.
Thank you, members of the board. Mr. Whitaker, if you would draw up the final order as drafted by the board today and include in that language regarding the default, because the board did hold the respondent in default in this case, and that does need to be in the final order. And if you would then, I believe the board voted at the outset of this hearing that if Mr. Watkins is not available, Mr. Crocker could sign his name. So if you would have that signed by either Mr. Watkins or Mr. Crocker and have it filed in my office, it will become final and effective the date it's filed with my office. Thank you, members of the board. Thank you, Mr. Whitaker.
Thank you, Your Honor.
And if anybody has any exhibits over there, I need those before I leave. And otherwise, I turn it back over to you, Mr. Watkins.
Thank you very much. All right. Mark, has lunch arrived?
Yes.
Y'all want to take just a brief minute to grab your lunch, and maybe while we're eating, we can conduct committee meetings? Is that okay with everybody?
Right.
You're from Ms. Bertie Hobbs. Ms. Hobbs passed the exam before the 150-hour education requirement. She passed in May of 1990 and passed the ethics exam in February of 91. She has just now, I guess, submitted an application for certification, and she has since earned the 150-hour rule. However, she did not do that within the 200-day window, which says you have to complete your 200 hours of education, 150 hours of education within 200 days of passing the CPA exam, I believe, and the ethics exam. The board discussed or the committee discussed this, and we felt that we recommend that the board approve her application.
Okay.
She's completed all, I guess, a little more. She's done everything she's supposed to do. The only, I guess, where she missed was timing.
I get, there's only, how many of them were there? 6?
Well, there's one we need to discuss.
That's right. Okay. Okay, I have a motion by the committee, by Mr. Eldridge.
Second motion.
I have a second by Mr. Stewart. Any discussion on that topic? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Okay, the ayes have it.
Second item we have is consideration of request for licensure by Miss Doreen Marie Rowe. Ms. Rowe passed the exam in 1993 and applied for licensure in February of this year, just before the 10-year expiration of exam scores went into effect. Though she submitted an application and fees before the exam expiration date, she did not take the ethics exam until after the rule went into effect on 3/11/14. I believe that where this came from is we don't consider an application to be submitted until all necessary items have been submitted. So The committee again discussed this and felt that, recommends that the board approve her request for licensure for Miss Doreen Marie Rowe.
I have a motion by Mr. Eldridge, excuse me. Do I have a second?
Second.
I have a second by Mr. Stewart. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Okay, the motion carries.
Next item we had is a request for abatement of a late fee for annual licensure, or biannual, what do you call it, licensure fee by Miss Judy Alton. Miss Alton requests an abatement of a renewal fee, late fee, due to hospitalization and rehabilitation following surgery. Miss Alton was hospitalized from December 10th, 2013 through January 23rd of 2014, which was her reasoning for why she didn't send her licensing fee in on time, and she's asking we abate the $100 penalty. The committee discussed this and recommends that pending submission of to staff proof of her hospitalization during that time, that we would grant her request to abate the $100 late fee penalty. And I'll make that as a motion.
A motion by Mr. Eldridge. Is there a second?
Second.
I have a second by Mr. Alexander. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? The motion carries.
The next item for consideration is a request from LOMA, which is a Life Office Management Association, to have their exams and certifications be granted CPE credit. In the past, we've had several requests for CPE credit from these exams, which we've generally granted pre-approval for CPE credit for such exams. The committee discussed yesterday and reviewed the different certificate levels, and there's 3 levels for which LOMA offers. There's the certificate level, the ALMI level, which is the Associate Life Management Institute, and then there's the FLMI, which is a Fellow of Life Management Institute. Concerns we had was that did these exams cover technical topics, or should they be considered other topics? And the committee recommended that we grant technical CPE for the FLMI level. Addition to that, one thing we did not discuss, and I wanted to bring this up just to maybe be more efficient. In the past, we've granted, I believe it's other CPE credit for, is that correct, Mark? We've granted other CPE credit for these other, for basically for all of these, the certificate level and ALMI. I'd like to add to the motion or throw out for discussion that we go ahead and grant, so that we don't, because we're going to get a request every time someone takes these exams. Just go ahead and offer other CPE or non-technical CPE for the other 2 certificate levels, which would be the certificate level and the ALMI level, and then grant technical CPE for the FLMI level.
Have a motion on the floor. Do you have a second?
I'm not sure what he just said.
Okay.
All right.
I mean, I heard the discussion yesterday about this, and looking at that piece of paper that described what each one of those levels were and everything. The only one that really got into any accounting was the final level.
That's right.
Why? What are you?
I'm adding in there non-technical, which we've always approved all 3 of these as non-technical CPE. The only change we're making, number 1, is we're approving it all as CPE, so that we don't have to have individual submissions for this, because I think we've had several of these. And then we're saying that the FLMI level, based on our understanding of the course, would qualify for A&A technical hours. Only the FLMI.
A&A?
Yes.
Okay. No, I see what you're saying. Okay.
I'm just trying to save us from getting applications on this however often. Being efficient.
Okay. I have a motion. Did I get a second?
Second.
I got a second by Mr. Blofus. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? The ayes have it.
All right, the next item we had for discussion and consideration was a request that business valuation courses be counted as technical CPE. The committee discussed this and felt that this was a reasonable request and recommends that the board approve business valuation CPE be counted as technical CPE or A&A CPE.
Okay, I have a motion. Do I have a second?
Second.
I have a second by Dr. Spiceland. Any discussion? Is this the one you wanted to recuse yourself from voting?
Oh, yeah.
Okay, Mr. Alexander has stated, just for the record, that he does a lot of this work and does not want to be in on this vote for the appearance factor of something improperly affecting him. So just please note that he is abstaining.
Question.
Yes.
When I looked at the list of business valuation courses, it looked like the preponderance of all his CPE was business valuation. There was very little other accounting or technical issues. Am I recalling it correctly?
Yeah, I think that's, majority of it was, you talking about this one, the person uses the example?
Right.
Yeah, I think, and when we discussed yesterday, I think that we came to the conclusion that the knowledge level and skills necessary in these courses were covering A&A information. It's just under the packaging of business valuation.
Okay, so I had a motion. Did I have a second? Dr. Spiceland was a second. Okay. Any further discussion? Hearing none, all those in favor signify by aye.
Aye.
Any noes? Just note that Mr. Alexander was abstaining.
Last item we had, excuse me, was an ethics course application from Sequoia CPE. Our staff have reviewed the application and found the course to be in compliance with our standards. It's noted that Sequoia CPE is a NASBA registered sponsor. The committee didn't necessarily have a problem with this application. What we wanted to do is bring before the board's attention the need to, I guess, adjust or consider adjusting our state level, our state specific CPE, maybe to be more efficient, and maybe consider being being a provider for this at little or no cost for our members or for our certificate holders, rather than getting applications from numerous CPE providers, having to review all that and keep up with it over a long period of time. It may be a service that we want to offer our certificate holders. So I'll just throw it out there for discussion.
It just seems like if we have, I think currently we have 20 providers of state-specific ethics that we've pre-approved. And I'm sure we're going to get a lot more in the future. And I guess the thing is when we're talking about state-specific ethics, one, I feel like this board is probably the best provider of that information because we see the issues and the things that affect our state specifically. But as we get further and further out, how do we control 30 and 40 providers of state-specific ethics, and how do we know what they're submitting is what they are? I mean, do we trust every one of them to continue to provide that state-specific piece, or is it the same course recycled every year and not really dynamic and changing? So I had just raised the question of, do we need to start to think about limiting the number of providers for state-specific ethics? Not trying to create a market for anybody, but one, I think this board could do that for free for our membership. And this gets back to our more electronic means of rolling out state-specific ethics from this board and continuing down that path, and then not having 20 and 30 more providers of state-specific ethics. And that's just a discussion point.
Ask a question. Mark, y'all do obviously free CPEs for certain requests throughout the state.
Yes, definitely.
How much trouble would it be to take one of those courses and film it and be able to broadcast it on our website as, and grant CPE for that with some sort of, maybe a quiz? I mean, is that a very costly endeavor?
I don't think it's costly, Stephen. We just haven't done it. It's the idea of having to get the quiz together and making sure they're graded somehow. I'll have to talk to our IT staff to see if we can do that.
Could we get something for the?
Well, and I'll tell you, I think Brad has offered in the past to assist from the society standpoint in helping us get to that point. I don't think he's excited about us doing it for free, but I know that he was more than willing to help with the process. So, in fact, I think he said you may have been recorded recently at one of the state.
ESCPA offers so much CPE.
Yep.
This is just a very small slice
It's
of
a
your
blip.
pie, so I think you'd be kind of glad to get rid of it.
Can you
because
get?
it does require constant updating.
Can you get with them and maybe have something put together for our next board meeting to discuss that?
I will try to have something for you in October.
Okay.
I have a question for Mr. Whitaker, if I could, on this topic. If we as a board limit the number of providers in any CPE category for other than, it doesn't meet our standards, I mean, if we just impose some limitation, do we expose ourselves to some kind of challenge? I'm thinking like restraint of trade or.
Not so much sure about the restraint of trade, because that's typically more of a federal jurisdiction sort of issue. I think the bigger concern, if if it were to somehow run afoul of something, and not having researched this, I don't know for sure, so don't hold me to this, but just like the ALJ in the formal hearing always says you can't do things arbitrary and capricious manner because that'll get overturned on appeal. If there's not some method behind the madness, as it were, and something to ensure consistent and fair treatment of similarly situated groups, and then you start kind of picking and choosing winners and losers, I think that's where it kind of gets into murky territory.
I get into some of this just being, if you live in Tennessee and you operate under the Tennessee rules and regulations, then maybe you're in a better position to be in tune with what works or what we're concerned about in Tennessee. It's like if you got a provider from California who's providing state-specific ethics in Tennessee, I mean, granted, we're reviewing the initial application, but then, how are we sure what they're teaching is what we want them to teach? Now, I know, like I said, I know we review the course content before we approve it, but it just gets to the point of, are they really addressing what we really want them to address? And I guess that is incumbent upon us to review that, but.
Or are they just taking advantage of the fact that so many CPAs in Tennessee have to have the state ethics? And, I kind of see our role as helping protect CPAs from being taken advantage of in the state by our own requirement.
Well, and the bottom line is, if we can roll out a free product to our constituents, then I don't know why anybody would pay to take a state-specific ethics course. I could be wrong, unless it's just provided as part of another conference or something.
With that said, even if we do get application requests, I think we, and if it meets our standards, I still think we need to, approve it.
Approve this one.
I had a little bit different question about this, that's sort of looking through the course that this company offered. On page 41, well, they skipped 42, but 41 and 43, they list disciplinary actions that this board has taken, and they list the individual names. And I don't understand where this information came from. When these things come up before us, we don't have names. All we have is
Until they're
some
ruled
number
upon.
assigned to us.
But once we've ruled, it becomes public record.
Oh, really?
This is videotaped, this whole thing, and it's on the web.
But each person's name that didn't appear to us when we voted on it then becomes a public record?
Once it is actually
What-
adjudicated, or however you want to term it, then it becomes part of the official record, and all of the names, everything's public. I mean, am I
For
speaking?
example,
incorrectly?
Mr. Hoss, when we bring a case to you and we'll give you that little blurb about it, and we're going to say our proposal is revocation with the authority to settle with the signature signing of a formal consent order. Once the respondent signs that consent order and sends it back to us, that is public record, and that goes on our disciplinary action report.
And the only reason they're not giving you those names in advance is that to avoid any, I don't know, prejudice or, I mean, any of that at the beginning is to, I mean, I'm speaking correctly, right?
You said it goes on our disciplinary report. What are you talking about there? What's that?
This disciplinary action report that is what you see here in part of their case file or their case study, that is actually on the website.
Our website?
Yes, sir. And it's on the department's website as well.
Thank you. I appreciate the information.
How many outside vendors do we have outside the state of Tennessee that are offering state-specific?
Aaron, do you have any idea?
I don't know. Several of them are national companies, such
I
as
would assume
Western-
that the
Western
majority of them,
CPE.
I mean, the State Society would be probably,
We've probably approved 6 this year, I think.
yeah.
Well, then you have some local providers like Perry Moore and Dennis
Oh, yeah.
Dicus, but yes, most of the big companies are going to offer it because they're offering it to all states.
Right.
They're creating a module for each state.
Okay. I guess we need a motion to approve this course since it meets our guidelines.
I'll make that motion.
Do I have a second? Second?
Second.
Okay, Mr. Halls gives a second. Any discussion? All those in favor signify by saying aye.
Aye.
Any noes? The ayes have it.
That was all the items that our committee had for discussion.
Can I bring up one thing as part of licensing, since we
Sure.
had this last case? Mark, I guess if we've got these expired licenses out there, do we need to consider something, and maybe this is a directive for the licensing committee, do we need to establish some ground rules for what to do with expired status after some period of time? I mean, whether it be 2 years, 4 years, that they be revoked or whatever. I mean, it doesn't seem logical that we have an expired license sitting out there for 13 years.
We have discussed that in the past, Mr. Watkins. We have never followed through on a recommendation to the full board. In many states, administrative revocation is a matter of course. Mississippi is an example. You don't renew it, you're revoked.
Okay,
90 days.
90 days. I mean, I don't know if I want to go that short of a time frame, but I mean,
You don't want to do what Mississippi does, but
yeah, I just think that the committee ought to consider some
some length of time.
some length of time or something. And then in second, on that front, we had talked about putting a box on the applications for licensing that maybe
On the
they paid their
professional
professional
privilege.
can't speak, professional privilege tax.
Can we put those 2 items to be considered in our committee next, in October? Or
Okay, what are
can
we talking about, professional privilege tax?
Well, remember, we were talking about when people are renewing their license, that a box be established
Oh, yes, the question.
that
Okay.
says in an affirmative step that, yes, I have paid my professional privilege tax. I don't know if there's any legal issue with that, but I don't see why there would be.
That may require some-
It may require some legal research. The Accountancy Act and rules do not specify timely privilege tax, even under the pending, at some future date, revised rule that authorizes discipline for non-payment of privilege tax. That doesn't establish it as a condition precedent to licensure necessarily. Now, in the legislative review that we're going to be doing later, that Mark referenced in his report earlier this morning, there have been statutory steps taken to try and, I guess, take care of it on the back end if somebody hasn't paid their
Let me
privilege
ask you
tax.
this. We're going to
Okay.
be doing a rulemaking hearing at some point in the near future, right? We've got a couple things in the hopper. Is that correct? I mean, is that something that we could address through that process, or?
You could address it through that process, but it would probably.
I'm saying, will that alleviate your objections?
Without knowing what the text of that looks like, I couldn't commit to it, but I could work on it if that's the committee's
Right.
desire to see what, if anything, could be done on the privilege tax on the front end.
My thought is it's one thing to not pay it and not be asked the question, did you pay it? I think some people that may play around with that, if they see that as a question, might think twice.
Well,
Or it may be an incentive, let's say, because now they're having to answer in the affirmative, yes, I have done this. I'm just saying I think that would benefit
I don't think,
us.
this is subject to management and division approval, but the part about asking the question on the renewal form doesn't seem problematic from any sort of due process considerations. But anytime you get into affecting a licensee's substantive property right in their license, including their right to renew or not, that's when you get into requiring probably at least a rule, but in some cases even a statute change, depending on what
If they
it
don't
is.
pay for the privilege to have that license, then
And we
do
already.
they have a property right? I'm asking.
I mean, we're already saying that if they don't pay the privilege tax, it will be revoked, right?
Well, if the board's proposed rule change that's in the hopper now is approved, that will be a grounds for discipline up to and including revocation, but it's not, that'll be up to the board's discretion as to what actual discipline to impose. Like with any other violation, under the Accountancy Act, it could be all the way up to revocation or something less. But there's no mandatory provision saying that this is what it must be in the event of that violation.
I think all we want to do is just ask the question, just have the question on there.
Yeah, and my thought process is, let's let the committee discuss, and maybe they can work in conjunction with you to establish a way that we could do that, find a way to make that happen.
Well, I think the easiest way to do that, there's a rule change pending on the privilege tax being a specific offense subjecting someone to discipline, but I think you could handle it under the discreditable act rule that you have now for if that question appears on the renewal form and it's falsely answered in the affirmative, that's a discreditable act because you affirmatively made a false statement to the board as part of your application. And so I don't think there's anything additional required if you go that route.
Incorporated in the.
Okay. Mark, do you have any objections to that?
Let me just point out one or two things to you as I see it. One, you're going to have a timing problem because the professional privilege tax is not assessed until June the 1st.
I got a verbiage change to fix that. How about I'm current on my privilege taxes?
I was thinking when
Yeah.
you brought it up.
Well, you can say that, but keep in mind that we're going to get a notification 90 days after they don't pay. So we're going to be getting notifications in September if they haven't paid.
Well, again, it's just a question that they've got to answer in the affirmative saying, hey, I am
not
current.
delinquent. Okay.
And I think it's as much a reminder. Some people just, that may be the one thing that makes them go check and verify that they paid. Whether we use it after that would be a different matter. What we really want is something that brings it to their attention.
Okay.
Could I ask one question about Mississippi and what they do? Your 90 days after expiration leading to revocation, is that based in policy, rule, or law? Rule. Thank you.
Basically, our annual renewal fee of $100, 110, whatever it is, goes along with the license renewal at the same time. So if they don't pay that annual renewal fee, at the end of 90 days, a notice of fee may actually take 5 or 6 months, but it is done.
Okay.
Thank you, Mr. Eldridge. I'm going to leave now. But Casey will take us home here. But Mr. Barks, I did want to say thank you for the lunch, and we appreciate you being here. I'm sorry you've had to sit through everything today, and I sincerely apologize.
I learned a few things.
I have to run out on your presentation, but feel free to call me anytime if you want to discuss anything, so.
All it has been.
That's
Have a great day. Great, thank you.
I think at this point, we've got one more committee report to go, and that is the probable cause committee, and so I will call on Don Royston to present that report.
Okay, first thing I'd like to do is, Mr. Mills is in the back of the room now, but he's on his way back up. If you'll go to your tabs, I believe the last tab from the bottom is the status of open complaints in alphabetical order. Mr. Mills has a report on that, and he's give proper credit to the. And he's going to give proper credit to the producer of his surprise.
True. If y'all will look at your report. Look on page 2, you can see our year-to-date by quarter. We're down again, a couple of cases. You can also see that, of course, we had 4 formal set. We've knocked 2 of those out today. I think in legal, you're going to resolve 10 of those cases. So we're trying to get some fresh blood in here. We're running low. Hopefully we'll get some more cases for you for next time. But we are making progress. Excuse me. We're getting them to legal. Legal's getting them to you faster and faster. What Mr. Royston was talking about is, if you look on the next page, we have a beautiful color chart. And I cannot take credit for it, will not take credit for it as bad as I wanted to. Ms. Karen Condon is responsible for that because she knows how much CPAs love charts. Y'all can stop and tell her how wonderful that looks, and maybe she'll do it for us every time. I'd be glad to entertain any questions. Otherwise, that's all I have.
Anybody got any questions for Mr. Mills? We discussed in our committee yesterday the importance of something Mr. Crocker brought up at the State CPA Convention, of informing our members that they are our eyes and ears, and encouraging them to and even working with our bankers and people that see financials to report, ask a question. It doesn't have to be a formal complaint to ask a question and say, is there something here? But if you see it out there, or have a friend, if you can, and we thought if the TSCPA could work with Mark or one of the investigators, they're probably tired of hearing Mark, but about telling the story of that, if they see something that's not right, let us know, and that's the only way we're going to police it, because we act on what's brought to us. So, I think Mark was going to try to get with you all at Tennessee Society and see if we could do a little piece somewhere about it. That concludes Mr. Mills' report. The next tab is under legal report. Whitaker, would you like to present the legal report for us for the, I believe there's 10 or 12 cases here. There's 10.
Thank you, Mr. Royston. As you pointed out, there are 10 complaints on this report. The first 3 do contain disciplinary recommendations for settlement via consent order. One of the things we discussed in committee yesterday, Mr. Haas, I believe, had asked a question about the formal hearing for the revocation of respondent's CPA license, language that appears as the very first thing in any disciplinary recommendation on these reports. That is simply stock legal language which makes clear for, posterity and the record that the board is authorizing a formal hearing up to and including revocation of the license, but then whatever follows that introductory language is the board's settlement offer. So based on that, when you put those two things together, you have authority to settle on these terms, but if not, then formal hearing for up to revocation. So that way, there's no argument after the fact by a respondent's attorney saying, oh, well, you capped yourself at this discipline as set forth in the consent order, so that's the ceiling of bidding for discipline, and we work from there down. So just kind of a protection measure for the board to ensure that the board has maximum latitude and discretion to impose the lawful discipline as it sees fit. I would say the two items that are maybe deserving of a little additional reading. Item number one, this is failure to exercise due professional care, allegation of untimely filing of an estate tax return resulting in a tax penalty. The civil penalty recommended in this matter is $2,000, which is $1,000 for the due professional care allegation and $1,000 for untimely response to the complaint, unless the board finds that the conduct in failing to file the tax return on time is somehow ongoing. You're probably looking at $2,000, at least at this juncture, as your civil penalty potential ceiling. And then item number 10 on the last page, that is a direct referral to litigation for a formal hearing. We had some discussion about that in committee yesterday. There are several allegations of material misstatements on audited financials and some other things in there. The committee discussed in some detail the need for balance between keeping cases moving along from a division and performance measure perspective and also protecting the integrity of the complaint process and the due process rights of the respondents that this board is charged with regulating. And at the conclusion of that discussion, seemed like the committee was comfortable with moving the case along in this manner on the basis that additional work may yet be required. It looks like there is some evidence to substantiate some of the findings, and so and we also may need an expert witness to testify as to some of these things that may be outside the subject matter expertise of Mr. Mills and Butler in terms of being able to serve as an expert witness. So the recommendation for direct referral to litigation at this point allows us to keep the case moving forward and allows Mr. Mills to do what he needs to do to finish up the remainder of the work, if any, and also for us to come to a conclusion as to whether we need an expert witness, and if so, what that person's expertise needs to be, and get going on that. If at some point in the future the board wishes to consider a settlement offer in this matter, then we could bring this case back to the board, or if the respondent in this matter, through their counsel, requests or extends a settlement offer, we would communicate that to the board on a future report. So with that, I will turn the report back over to Mr. Royston and for the full board to review, and I'll take any questions you have when everybody's read it.
Don,
Any questions? Yes, sir.
You want to give everybody just a few minutes to look this thing over a little more carefully, and then I guess what we need a recommendation from your committee. Let's take just a couple of minutes and look through this a little bit. So.
As a note also, we talked to the investigators yesterday on them and asked if there was anything that had changed since the reports or the sanctions, and the investigators are happy with the facts that are presented. We have to condense what's in these to protect the practitioner and the licensee so much that we're not privy to too much information, that we can figure out who it is we're talking about. That protects both them and us. So it's a delicate balance that Chris has to walk through each month. Everybody had a chance to look through the sanctions, and since we've had the discussions on the two larger ones, are there any questions on any of the particular cases we need to talk about or discuss individually? Hearing none, the probable cause committee would make a motion and a recommendation to the board to present the required actions on these 12 cases. Yes, sir.
10 cases.
10 cases, excuse me. I want to put 2 more on there that we took off. So, these 10 cases, I make the recommendation that we accept your all's recommendations.
Got a motion, do I have a second?
Second.
Okay, any further discussion on any of the cases or the motion? Hearing none, all in favor, if you would signify by saying aye.
Aye.
Any opposed? Okay, wonder on the next item on the agenda, if we shouldn't give our guest, Mr. Jim Burks, a chance to make his presentation. Again, sorry you've had to sit through such a long meeting so far, but.
It's been very interesting. Our hearings in Mississippi don't take as long as your hearings. But yours were very formal, and it was very interesting and very good. I'm the Southeast Regional Director on the NASBA Board of Directors, and I have the opportunity to come and visit with you today. Want to talk to you about a few things that's going on in NASBA, and in preparing for my presentation today, I kind of listed out NASBA services and what all NASBA provides. And I started going down it, and I said, well, Tennessee does that one, and they do this one, and they participate in this one, and they participate. And I think every service just about that NASBA offers, you are a participant in, such as the Accountant Licensee Database. I know you all are familiar with the legislative support. You just started CPE tracking. Mississippi looked at CPE tracking, wanted to do it. Our executive director came back and said they had a problem counting for carryover hours. They couldn't, we were going to have to do all that manually every year, and so we didn't sign up for CPE tracking, but probably will. And then the one thing that I did find that you all don't participate in is the newsletter in the communications department. NASBA provides a newsletter free of charge. They will design the newsletter for you, let you approve it. They will print the newsletter for you. Generally, you'll have a section or two where your investigator may want to have some comments, your chair may want to have some comments, and even your ED may want to have some comments in the letter. And you can put those into the letter, but they do all of that for you free. Mississippi, we did that. We got on board around the 1st of March, and we sent out our first newsletter right after tax season was over. Got on our project and how fast they designed our newsletter for us. We do it on a quarterly basis. You can do it monthly. You can do it semi-annually or annually, whatever you want to do. But NASBA will assist you in all of that. You pick the articles that go in the newsletter. You can write a few, but I'm telling you, it is a wonderful thing. We got a lot of favorable feedback from our licensees with our first newsletter, and we like I said, we do it quarterly. So I would encourage you to look into the newsletter. The NASBA committees
Ask a question. Is there an electronic version of that?
Yes.
Or is that a,
It's electronic. We
all
send it out to
electronic.
our licensees electronically. We had a few, Stephen, we had a few that said, hey, I can't get that electronically. And we had hard copies. I think we had about 100 hard copies that we had printed that we can send out. So, but it is electronic version, goes out to email addresses. Committee interest, committees, NASBA has 20-something committees. I encourage all of you to sign up for a committee. You fill out a committee interest form in about April of each year, and when the new vice chair starts forming his committees, if you fill out a committee interest form, he will put you, or he or she will put you on a committee. And the committees are great committees. I've been chair of the bylaws committee too long. I've been in it for 3 years, and we've had to deal with some very interesting subject matters. We have a regulatory response committee that responds to drafts with regard to A&A issues, international as well as coming from the FASB. We have some wonderful, we have CPE committees. We have wonderful committees. You just need to pick one out that you like and send in a committee interest form. Legislative support, I just want to mention that John Johnson, Dan Dustin, Ken Bishop, Colleen Conrad, anytime you need them, they're there. John Johnson keeps up with all the legislation that's going on throughout the 55 jurisdictions. He will send you alerts to tell you when there's legislation that's been introduced that you need to pay attention to, and if you need them to help, and they will come and testify before the legislature. They will draft documents for you. They're doing a wonderful job, and they helped Mississippi last year. We had rumors of Secretary of State wanting to consolidate a bunch of these special funds, as they call them, special agencies, special fund agencies, and they stayed on top of that, kept giving us alerts, and it finally went away. But those things have a way of coming back the next year. But they do a great job, and John will send notifications to Mark when something is happening or a bill's been introduced in your state. So, but just remember, they're there to help you, and they do it free. I mean, they come talk and testify for you. Firm mobility, there are 17 states right now that have firm mobility. Tennessee is one of those firms, one of the states that has firm mobility. The UAA language for firm mobility has been finalized, and it's in the UAA. The 17 states that have firm mobility, all of them have a different rules with regard to the firm mobility. It would be nice if we could get some changes made to get that closer together, closer to UAA, just to have some uniformity in the language. And you're going to hear a lot about uniformity. And it's not about firm mobility. Uniformity is going to be about rules and regulations between states. And I think Troy kind of alluded to that earlier. You're going to hear a lot about uniformity. You're going to hear a lot about the Code of Professional Ethics. There's a lot of disparity in the states with regard to their Code of Professional Ethics. Not everybody adopts the AICPA Code of Professional Ethics. Some that do adopt the AICPA Code of Professional Ethics, they also have some special rules in addition to that. One of the examples that's fresh with me is I had a licensee call, and Mark's gonna know what I'm talking about, but I had a licensee call me on the phone, and he said, y'all got to do, and we talking about Mississippi, he said, you all got to do something because I'm being disadvantaged in my audit proposals. And I'm like, what are you talking about? And he began to tell me how Tennessee, he competed against a Tennessee firm that had come into Mississippi. He said Tennessee allows testimonials They can put testimonials on their website, and they can put testimonials in their proposals. Mississippi does not allow testimonials. And he's a licensee for Mississippi, so his proposal didn't include testimonials. And he was absolutely convinced that's why he didn't get the job. Probably had something to do with pricing, would be my guess, but he was absolutely convinced that that was why he didn't get the job. And we had to do something to make, to have a level playing field. That's just an example. That's just an example of some of these uniformity things that you're going to see that, we need to be a little more uniform, particularly with our neighbors, so that we don't run into some of these issues. And I'm not asking you to change your testimonials because we have BKD in Jackson and they have testimonials all over their website. And so far we haven't elected to do anything about it on the Mississippi board. Then there are two other things that I want to call to your attention. Today you all talked about your peer review transparency and where you're trying to move. Well, what I'm going to tell you now is going to give you an additional incentive to move. Now you all of us have heard about Ethics Interpretation 101-3. Well, Ethics Interpretation 101-3 deals with non-attest services. December 15, 2014, part of non-attest service is going to be that CPAs can no longer prepare financial statements for an attest client unless you go through all the hoops that are associated with 101-3. You got to have somebody that knows what they're doing in management. You got to be able to make sure they understand them. And that's going into place in December 15, 2014. If you do governmental cash conversion to accrual, that's a no-no now. That's a non-attest service. So you're going to have to go again, jump through all those hoops that are in 101-3. So what I'm telling you is it sounds simple, but most of our licensees in Mississippi and most of the licensees I talk to have no idea that that's in 101-3. Now, where does it hit? It hits in peer review. The peer reviewers have been told that when they go do peer reviews, and December 15th is reports issued on or after December 15, 2014, they go do peer reviews and they find that the CPA has prepared the financial statements for the client on an attest engagement. And attest in most states, in most jurisdictions, is audit and reviews. But if they prepared the financial statements, then they are explicitly told you got to go look at the documentation. The documentation has got to say, this was a threat to my independence. This are the safeguards that I implemented to overcome those threats. And then my conclusion is that I am still independent. If you don't have that documentation in your work papers, you're going to get a pass with efficiency or a fail, depending upon how that continues, how rampant that is in your practice. So you need to pay attention. You need to pay attention to that. And I've been trying to tell our board in Mississippi, we need to get something out in our newsletters to remind our licensees that this is here and it's something you're going to have to deal with. If it's the SEC client, obviously you can't prepare the financial statements at all. And if it's a DOL client, you can't prepare the financial statement. And DOL being employee benefit plans, because we just fought that battle. So it's something that you need to pay attention to. You need to go into 101-3, read it, see what all those hoops are, and then be sure you document, your licensees document in the file. Now, what happened is a lot of them are not going to pay attention to it. They're not going to know it. So they're going to issue those peer review reports, and you all don't have access to those. Mississippi, we do. So we'll know which ones passed with deficiencies, we'll know which ones failed, and they'll be called in we'll have a hearing to talk to them about that. Last thing that I just wanted to mention to you today is that SARS 21, which is for compilation engagements, compilation and preparation engagements, which we've talked about. They've talked about it coming out it was supposed to have been released in April, then it was supposed to be released in May, then it was supposed to be released in August. Now it's October. But basically, the compilation this SARS is going to deal with compilation and preparation services. And if you do a compilation engagement, you got this criteria that you got to go by. If you do a preparation service, you've got this criteria to go by. Now, the preparation services would be like your bookkeeping clients, where you just, you print the financial statements. You cannot, in a preparation service, you do not have to put a letter on it, but you got to put the legend on each page, and the legend, and they keep working on the legend, but basically the legend says something like this: this financial statement was not prepared by a CPA, and therefore no assurance is provided, period. I can't tell you about all of your clients, but I can tell you about mine. And my client, I'm gonna say, you can't take that to the bank, but he'll take it to the bank. And the bank's not gonna accept that. And even though we don't provide assurance services on the compilation, they're gonna want to see a letter. And so when you get back over to the compilation engagement is going to be just like all the rest of them. You're going to have a provision there where you can say we are not independent if you prepared the financial statements and did everything else. And that's what most of mine are going to look like, because I probably will prepare the financial statements. But if you do jump through the hoops of 101-3, you can still issue a compilation report without stating that that you're not independent.
Is there something on NASBA's website, an article or something that you can refer us to that we could use as a baseline referring to this?
That's a good question. 101-3 is not on there. SARS is probably, the exposure draft is probably on there. But I'm telling you, the exposure draft has taken 3 or 4 turns. For instance, the real issue now on the preparation services is preparation services subject to peer review. Peer review folks are saying basically right now, no, it's not. But SARS is going to take the position that yes, it should be. And you say, well, what in the world do they review? Well, the SARS 21 says that if you do a preparation service, you got to have an engagement letter, and you got to have the legend. All they're going to be looking at is make sure you got an engagement letter and you got the legend on the file. So,
Ask a question about that.
yes.
You said with firms that just print financial statements out, say, one out of QuickBooks or whatever it is, that they've got to issue a statement on there saying that they were not independent. Is that
Right.
who monitors the non-accounting firms? Just a bookkeeping practice that they handle QuickBooks, and are they going to have to follow that rule? So does that not kind of create a little bit of a disadvantage for CPAs versus?
One of the past chairs, I'm proud you asked that, one of the past chairs of NASBA made the comment. He said, why in the world are we doing this? We have a franchise on this business, and now we're giving up the franchise. And that's basically what you're talking about on the preparations.
What was the response? Why would we want to create a disadvantage?
Nobody bothered to respond. But the SARS 20, you know SARS 8, which is the old bookkeeping stuff, that's gone. That's out when SARS 21 comes into place, impacts. But yes, it does disadvantage. I don't disagree with that. I guess the last thing that I would say, because I know I'm separating you all from being adjourned, the last thing I would encourage you is that come to the annual meeting. We're gonna have some fine speakers there. One of the luncheon speakers is gonna be Cokie
Roberts.
Cokie Roberts is gonna be one of the luncheon speakers, and we're gonna have Keating, and we're gonna Oh, yes, I better speak into the mic, I'm sorry. We're gonna have some great speakers. It starts on Sunday evening, November the 2nd, and it's over about 1 or 2 o'clock on November the 5th. And if you like to play golf, there's an annual golf tournament that is played on Sunday morning. And I don't know what golf course we're gonna be on, but it's fun. You get to meet a lot of great people. So I would encourage you, all of you that can, to attend the annual meeting. It's in Washington, D.C., but I will tell you, if you decide to come on Tuesday, November the 4th, is election day, so you need to absentee vote before you come to the annual meeting. That's all I have to say, other than I'm here to answer questions and tell you that NASBA is, we're there for our boards. There are 55 jurisdictions. We are member-driven and member-focused, and we want to be an advocate for the state boards of accountancy.
Okay, does anyone have any questions of Jim that you'd like to ask at this time? If I don't hear any, we again would like to thank you for taking your time to be here today and spend a long day with us.
Thank you for the invitation. I appreciate it.
All right, good deal.
Thanks again for lunch, too.
That brings us down. Mark, you look like you were about to say something.
Well, I'm going to recommend that we kind of flip-flop the last two things and let Mr. Crutchfield make his presentation before you go to Mr. Whitaker, if you don't mind.
I will take your advice. We'll do that.
Thank
Soon Mr. Crutchfield is coming to the microphone, so Mr.
Good afternoon, everyone. My name is Devon Crutchfield. I'm the sole member of a PLLC named Intracount PLLC. I'm here today because I would like to respectfully request that the board reconsider its decision to deny the firm names for Intracount PLLC. During the last meeting in May, I had proposed Intracount PLLC, Intracount Accounting Services, and Intracount Tax Services. There's some information that I feel that had the board been aware of at the time of their decision, the decision might have been made differently. So just a little bit of background about me. I absolutely love accounting, and I love being a CPA, and I've always had a dream of having my own part-time business. The name Intracount is something that it's pronounced Intracount. I noticed there was a little bit of difficulty there when I was watching the video of the last board meeting, trying to figure out how do you say the name, the nature of the business, and that sort of thing. It's Intracount. The reason why I chose it, I like the name. It was unique. It's short. It's something that I feel for my clientele who would, I suspect, be not opposed to working in an economy that's digital, technologically, advanced, that sort of thing. I don't think that they would have a problem with me using the name Intracount instead of perhaps my name. So I felt that the name would be appropriate. But specifically, the main reason I'm here is that all three names were denied solely based on what I feel, in my opinion, was an inadvertent but nevertheless inaccurate representation. Specifically, what happened was there was at first a little bit of discussion about the nature of the business, how do you say the name, that sort of thing. And then Mr. Watkins had basically, speaking to Dr. Spiceland, had basically said something to the nature of, you don't know what they do. And then Dr. Spiceland said, and they brought up the fact that it might be misleading. And then Mr. Watkins had noted, right, well, there's your answer. The board shared a laugh, and that was it. Then Mr. Whitaker had noted, well, I feel that the name, he said, he noted that I believe that they were making the argument that the name might be ambiguous rather than misleading, or excuse me, deceptive. And then there was a brief silence, and then someone made a motion to deny the name, didn't mention why, and then the motion was seconded and the name was denied. The issue at hand for me here is that, I reviewed all the emails that I had sent to the board, and the reality is that I just never, noted, I never said that the name could be misleading. Like Mr. I'd said, the name Intracount PLLC is ambiguous. However, I feel that a valid distinction can be drawn between ambiguity and deceptiveness, and I feel that the rule against misleading names is designed to address the latter. And so I feel that had the board known that, that wasn't my position, I feel like the board's outcome might have been a little bit different. And then just a couple of other points about the name Intracount PLLC. I do understand that it doesn't describe the nature of the business in particular, but it would seem that if I used my initials, for example, DRC, that wouldn't necessarily be a problem either. So if a name with initials is appropriate, even though it doesn't provide any information with respect to the nature of the business, it would seem that a name like Intracount PLLC would also be appropriate. And then in general, another point that I thought was interesting is that the board had kind of contemplated the idea of perhaps allowing grandfathering in the fictitious names that have been approved in the past, and then denying fictitious names going forward. And I feel that if the basis for a decision like that is that it's misleading and that fictitious names are inherently misleading, then it wouldn't be fair to basically allow every other fictitious name to continue to exist, because if we are doing this in the interest of the public and those names are truly misleading inherently, then they should be barred for everyone. Because the use of a fictitious name is, according to state law, is a prohibited activity, and the knowing violation of one of those prohibited activities is a misdemeanor. And so it seems like, that would be a problem for everyone at any period of time and not just at the applicant stage. So that's the information that I had specifically about Intracount. And I want to be clear because the rules say that the name can only be denied as misleading for a specific set of criteria, and I don't feel that the name meets any of those criteria for being misleading. And then it says, or unless it's deceptive, and I certainly don't feel that the name is deceptive. And so, I feel like if the board has a reason for why Intracount PLLC is a misleading or deceptive name, then I would be interested in hearing that and discussing that. And I also have some points related to fictitious names in general, because I feel that since the board contemplated denying fictitious names overall and making a rule change to that effect, it seems like if the issue and the problem is really that they're misleading, that wouldn't be necessary, because you already have the authority, the rule needed to go ahead and deny the name. And so it sounds to me like there might be a different issue there, that the board doesn't like those names. And I do have some points related to why I feel that first off, some of the reasons that I feel that the board kind of indicated why it didn't like those names and some points to those reasons. And then also some points about whether or not it's harmful to the public, which I feel ultimately is really the only reason why we would want to deny.
Mr. Crutchfield, would you communicate to the board what you indicated to me as the genesis of the intra-account name and how you came up with it, and so on and so forth? I mean, you and I had that conversation, but it might be beneficial to relate that to the board.
Sure. I think one of the things for me that was important is thinking about the marketing aspect of the business. And so one of the things that was important was obtaining a name, deciding upon a name that I feel that could be a brand, and that also feel that I could get a URL for, because in internet marketing, having a .com, having a shorter name, things of that nature are typically better for you. They're statistically, they're easier to get web traffic for. So that was one of the reasons. And I just wanted something that was creative and unique in my own. But other than that, I don't feel that there's really a specific reason or.
Okay, Mr. Crutchfield, anything else?
Sure. No, I mean, unless, like I said, I do have some points that I could discuss about fictitious names in general, because, it seems like the board doesn't like some things, maybe because they're vague, absurd sounding. Oh, specifically non-CPA owners hiding behind fictitious names. I feel that specifically with regard to that reason, that's something that could happen with any name. I mean, it's my understanding that if a non-CPA owner there's no requirement that a non-CPA owner have their name on the name of the firm. Now, please correct me if I'm wrong, but I don't think that's required. And so that seems to be an issue that denying fictitious names simply wouldn't address. And so it seems unfair to me to kind of use that as the impetus for denying these things. But no, I don't have any particular point that I'd like to discuss other than that, and I appreciate your time.
Can you tell me what intra-account means?
It doesn't
Other
mean,
than a brand that's marketable?
Right, it's just a name. It doesn't mean anything. Intra-account it simply doesn't, mean.
That was the problem that we had with it at the time, if I remember, is that it didn't say anything, and you're supposed to have, so that the public understands what it means, it's supposed to relate to who you are or what you are, and intra-account doesn't.
Well, it's my understanding that there isn't, the only rule with respect to a misleading name is that it doesn't mislead with respect to the nature of the business. The fact that you can't tell what the nature of the business isn't actually a problem, because it doesn't mean that it's misleading. However, I would say that I did offer intra-account accounting services and intra-account CPA services to specifically address the nature of the business if that was, in fact, the reason why the name wouldn't be approved.
Okay, I unfortunately was not here at the last meeting, and so I don't have the benefit of the discussion that took place. But I guess by allowing Mr. Crutchfield to be here today, we have opened this back up for reconsideration. And so, I guess I would just ask for any comments or discussion. Again, we can get Mr. Crutchfield back to the podium if there are questions for him. So at this point, we'll just open it up for discussion.
Chris, do you know what number it is, which in our laws and rules?
Yep, you're on page 53 Rule 0020-03-.15 relative to firms.
I remember correctly that
53, and I think what our discussion before centered, we were not picking on Mr. Crutchfield, actually. We were looking at a number of fictitious names, and our concern was that these names just we were opening this can of worms. And if you notice on number 2, that is on under 20-03.15, it says that fictitious name or initials of one or more present former partners, members, etc., may not be used unless such name has been registered with and approved, and it is not false or misleading. So I think part of the problem when we say yes to something, these names were just getting more and more bizarre. And the fact that they have no meaning or have some suggestion, because in this case, the fact that it doesn't represent really anything is misleading. It concerns me that when we start tacking on things, we are basically giving an approval to something that we really don't have the ability to recognize or approve. So I personally think that we should not open that can of worms anymore. And I understand there are a few fictitious names out there approved. I don't think we have necessarily the right or to go backwards, but I certainly think it's our responsibility to go forwards.
Mr. Crutchfield, if you'd like to step back to the podium and respond.
Just so that I can get a better understanding, when we say that a name like that is misleading, what impression is the name giving the public that is not true?
Read 2 in the rules, though, it says a CPA or PA firm name is misleading under 62-1-113 if, among other things, its name in Part E, it says contains one fictitious name. So, I mean, I think that was one of the other things we considered as a whole on this, was that we were just interpreting our rules as they're stated. It's not to single out any one particular firm or application. It's just to say, hey, this, these are the requests, and based on our understanding of our rules, they don't qualify. Because, I mean, inter-account would be considered, in my opinion, a fictitious name. Wouldn't you agree?
Well, I guess you're saying the criteria that you're saying it doesn't meet is what now? E, where it asks about?
It says it's considered a CPA firm or PA firm name is misleading, and I'm going to paraphrase, if among other things its name contains contains more than one fictitious name.
So are you saying that intra-account, which has no space in the name, is more than one fictitious name?
I would say inter-account would be a fictitious name.
Mr. Eldridge, I think his point is that that particular subsection of the rule you cited says contains more than one fictitious name. And pardon the example, but for example, if it was intra-account super-de-duper something PLLC, that's more than one fictitious something in there. But I think the way that rule is written says that one fictitious name, if approved and registered by the board under sub 2 and is not false or misleading, is acceptable, but then you have to go back up to D, which under 1, so we're looking at 1D, tends to mislead regarding the nature of the business or the affiliation of the trade name user with another business entity. I don't think we're at the, anywhere close to or relevant of, confusing with another business entity. So really, where you're drilling down the focus to is, does intra-account PLLC or not mislead regarding the nature of the business? And if the board's opinion of just intra-account PLLC is that it does, then whatever that explanation is how it is. But then the board might also wish to consider if the proposed alternatives by Mr. Crutchfield, i.e. intra-account accounting services, PLLC, or CPA, whatever the other thing was that he said, somehow alleviates the board's concerns in that regard.
That's fair. My dyslexia flared up there. I read it as, in my mind, one or more instead of more than one. Sorry.
I would like to point out that, as outlined in the minutes of the last meeting, when fictitious names were discussed, there were 5 names that were disallowed, and yours was one of them, but the other 4 were also disapproved. And the minutes outline considerable discussion that was had regarding our concern of opening the door up to proliferation of fictitious names.
Yes, sir. I understand that. One of the things that I'm interested in is it sounded like there's a problem that the prevalence of fictitious names is a problem, and it's difficult for me to understand. Like, I still can't seem to wrap my head around the idea that it's misleading, because I don't know what false impression is being given. But it's also kind of hard for me to understand why the prevalence of fictitious names is inherently a problem as well. Now, I can't speak for the other firms. I mean, one of the reasons that was given for one of the other firms was, well, we can't endorse, if you have, for example, church auditing in your name, we can't actually say that you're good at performing church audits. So I can't really speak for the reasons why they were denied, but for IntraCount, there was about a minute of discussion before the name was denied, and then no reason was given for how it was misleading, other than, as I said before, an inaccurate representation that I had somehow indicated that the name could be misleading, which doesn't seem to be a fair basis to deny a name, in my opinion.
Mr. Crutchfield, if I may ask a question, and if I'm misstating part of what you're asking, please say so, but it seems to me that you're asking the board to distinguish, if they can, between names like IntraCount that, mean nothing or are for marketing purposes or whatever it means or doesn't mean, versus, for example, the church audit, which specifically says, okay, this name says that we are experts in church stuff, and the board doesn't know this for sure, so it could be misleading for the board to approve something that states subject matter expertise in a specific area, as opposed to a name that, not to put too fine a point on it, but you said basically means nothing and is for website and marketing purposes. Does a name leading to nothing in the public's mind, other than maybe a website, is that misleading, versus is it misleading to claim subject matter expertise in a specific area? Is that somewhere in the ballpark?
Right, that is definitely in the ballpark, because I guess my concern here is in some cases I could understand the rationale, but for IntraCount, since I don't have any clue as to what false perception could be given to the public, it's hard for me to understand how the name could be misleading. And then if it's just because there is no indication of the nature of the business, then I put accounting and CPA services, so I tried to alleviate the board's concern there. And so I respect the fact that the board may not like the name, but I'm trying to understand how it's actually misleading. And if the board doesn't find that it's actually misleading, I would just respectfully request that the board approve the name.
Tell you, I wasn't here again last meeting, but I did read the, I guess, the background information that was provided on this, and I have listened to your arguments today, Mr. Crutchfield. I think you got some very good arguments and some very strong points. And I wonder about, sometimes it's cause you to think about the rule as it's written, and is it a good rule? Is it time for the rule to be changed? I mean, is there something wrong with it? You talk about fictitious names. I mean, KPMG, What does that mean?
Plainville
maybe-
Pete Murray Gurgler.
Don't probably look out here that knows that.
What's it mean?
I think we
I'm
also.
saying the
I think-
world has changed. I mean, I've got a son-in-law that works for KPMG, so I know what it means, but also got a daughter that worked for them. But I guess I buy into your arguments about the name. I mean, to me, the big thing from this board's perspective ought to be, is it misleading? Is somebody being harmed with it? Are we implying a specialty that doesn't exist, or a service that is wrong, or whatever? So to me, the misleading part of it is much more important than whether it's fictitious or not. But
I think it
those are just-
also goes to a level of professionalism too, because we could have someone in tomorrow saying, I want to name mine supercalifragilisticexpialidocious. And that's not misleading, or it is misleading. Or, I mean, it's a fictitious name. So it could be defended under the same grounds that he's making right now. So that was our concern at the meeting before. When we open the door, at what point do we draw the line?
Well, the door's already open, I think.
Well, doesn't mean that we have to proceed forward.
It seems to me that we're talking about establishing a sense of responsibility. I mean, we as CPAs every day deal with responsibility with our clients in everything we do. And by not having a proper name on the door that identifies those in that firm who are responsible, it seems to me you're evading the issue of responsibility. If you put Intercount on there, who knows? I don't understand why you can't just use your word Crutchfield. That part, Crutchfield CPA Services, that's a very fine name. It'd be a very good name to go on a CPA firm's door. And it identifies the parties that are responsible for the services that firm's going to provide.
And Henry, what about KPMG, for example, or PwC?
KPMG is a huge national firm. We all know that they have hundreds of partners
Let's
that are
use mine,
responsible for those
ATA.
services.
Use my firm, ATA. Those guys, they're all deceased. There's nobody, the name, they're all not.
There's a lot of firms out there that have former deceased partners listed in their names.
I agree, but what I'm saying is just what you said about the person that's responsible.
Well, in this case, you've got one person that would, Crutchfield CPA Services, that would be the owner of the firm that would be responsible for those services. In your case, you've got several partners there that
who are dead.
Well, I hope you got some that are alive.
No, I'm talking in regards to the name. The argument you said was that those responsible for the work being performed were listed on the door.
It still defines an entity there, though, that's been around for an awful long time. It's been providing professional services to that community for many, many years. And you've got a set of partners now that are maybe not the ones that are on the name, but they're the ones that own the firm. They're the ones that are providing the responsibility.
And they bought into that reputation when they carried on the name.
Then it degrades down to just some initials of people. I mean, now it becomes, I'm just using example, like KPMG, for example. It's now that doesn't represent any particular person's name. It's just a
brand.
Right.
It's a brand.
There's a lot of firms that are going to use either using initials or they're shortening to one name.
Well, I guess my point is this, and I'm trying to remember back from the discussion we had 3 months ago, because I think he's made some very valid points. The thing we were concerned with was misleading names. For example, what was the...
One of them was something.
The best accounting service, the best accounting service.
The other ones were Real Tax and Accounting, Simple Accounting Solutions, Church Audit.
And the Call 3, was that?
And Call 3 CPA.
And honestly, from thinking about it, I do think, in my opinion, this is just me talking, that there is a difference between wanting to be called the best or Simple Accounting Services, because that's, we're endorsing something saying that it's simple, when in fact it may be misleading and it may be very very difficult, as opposed to something now that's more or less a brand, it's not implying anything other than that's my name, just like in the example we used, KPMG or whatever, E&Y and, all those firm names.
Or
Mr.
pink.
Eldridge,
It's a
if I-
brand.
I mean, if they came in and said they were pink, I want to be pink, are we going to say that's okay, or?
I mean,
or
I
floppy?
guess in that point, you're not implying any better services than anything else.
Pink, floppy, silly?
mean,
You're right.
If somebody wants to do that, I'd be surprised. I mean, that's kind of extreme, but.
No, his point is a brand. He wants to be recognized as something unique. That's the whole purpose behind the name. The reason he doesn't want to use his name, he wants to do something that's different, that's going to call attention. It's a marketing ploy.
I would say KPMG is unique and is a brand.
Well, it was originally.
But it evolved into something else.
That's true, but after a certain length of time, it evolved into a symbol of respect.
Let me ask you this: and I'm playing devil's advocate, if he found 4 partners to go in, that the partners' initials were
NTRA.
Would that qualify then?
It would.
Yes, it does.
Absolutely, it
under
would.
our rules.
Because it means something.
It does mean something, and it represents those people.
Mr. Eldridge, I'm sorry, Mr. Crutchfield, if I can ask just to make sure that I understand what you're saying. You're saying that the issue that you're seeing is if the board is somehow expressing approval as to the quality of service or the subject matter area of expertise of a firm contained in the name. That is your concern, that those two could potentially be misleading from the standpoint of board endorsement of real, best, simple, or church or something.
Right. And I'll stand corrected if it's not true, but that was one of the points I thought that I brought up back in, you saw, I don't know, I haven't seen the video, but that was one of the questions that came up from somebody. I thought it was me, it may have been other people, that it was more of a, if you're trying to quantify or qualify the services through the name, that was not something we would allow. That was one of the discussion points. I guess my point is I think he makes a good point about it's a brand, and just because it's a brand doesn't mean it's misleading.
I'd like to move that the subject of fictitious names be referred back to the licensing committee. Consideration for all the matters that have just been reviewed here.
Maybe before I ask for a second, we've got a motion here. Is that the appropriate place for that to go, or is it?
That's where it came from.
That was where it came from.
Talking about a rule change, aren't we, or a rule that?
Well, this is still an interpretation,
Well, a
because
law interpretation, so somebody else has to deal with it.
because it's going to go right back to
I'm
the
joking,
same
by the way.
committee.
No, I mean, and I think I would be fine with that. I assume I can speak now, Mr. Chairman.
We're out of order anyway. Go
That's
ahead.
true.
Yeah.
No, I think that, I think he's brought some good points for us to add to the discussion, and I have no problem with revisiting that in our committee. I do think a law interpretation we're going to ask for that as far as give us a breakdown on what can do. So, Mr. Whitaker, we'll need that for our committee if we pass this motion.
The motion can die for a lack of a second.
Well, let me ask you to restate the motion or repeat the motion.
I go back to the minutes of the last meeting when the licensing committee reported on this matter, and I'm moving that the matter be reconsidered by the licensing committee, the whole issue of fictitious names and the related rules be re-examined by the licensing committee.
Is that applicable only to Mr. Crutchfield?
No, it's the subject of fictitious names in general.
Okay, we got a motion. I guess we need to.
I'll second that, and I have a question from Mr. Crocker.
Okay, we got a motion and a second. Any further discussion on the motion?
I would like to limit it to this specific matter, quite frankly. I think
Well, that's going to be the problem, though. We can't consider this matter without considering every future thing that may come.
we can, but there'll be a different committee here 5 years from now. And their interpretation will be
But
totally
my
different from
fiduciary
ours.
duty
okay?
says that.
One possibility, if there's a friendly amendment to Mr. Bloff's motion, to refer this subject generally back to the licensing committee and along with something to reconsider Mr. Crutchfield's name in light of today's discussion. If that is the will of the board, then that might be an appropriate motion.
I just bring that up because Mr. Crutchfield is here before us. That's the reason we're going back to consider it, to consider others other than Mr. Crutchfield. When we haven't been asked to, I think it's going to open up even more. We're going to need legal counsel to assist us. Trying to contain this a little bit, but we'll do whatever the board.
Hey, Mr.
We had I think the policy that Mark was following up until the request by Church Audit to have the name change. Prior to that point, this was being done not by the board, but we had delegated that authority to Mark to do as these requests came in. Is that not right, Mark? As I understand, we were not deliberating on each one of these name changes. It wasn't us but we had delegated to Mark the authority to do that. Right. And then all of a sudden this request came in from these guys to change their name to Church Audit, and Mark brought that before the board, and suddenly we're faced with having to deal with fictitious names.
I think there were a number that
Right.
were in question. So anytime one came in that was questionable, you brought it before the board, correct?
I think that was at our January meeting, and lo and behold, at the April meeting, we had 5 or 6 of them come up. Bingo. So now we're addressing the whole subject of fictitious names.
We are. And I think that's going to continue.
Yeah.
So,
I agree with Vic, though. I think that's going to be a much bigger issue than just Mr. Crutchfield's request, and I think there could be legal ramifications from whatever we do there. We've got a current rule that addresses this whole issue, and I guess, to me, we need to operate within that until that rule's changed.
well, that's an interpretation of misleading, though. That our current rule is an interpretation of what we consider misleading. Personally, I consider that misleading. So
Personal
it is.
interpretation, yeah, so I guess each
And
of us.
I would say, if we are looking at this in terms of our own, how we're going to personally interpret it each time, then it's going to continue to be an issue. If we want to look at, do we change the law, how it's written, to be more specific so that we don't have any gray area, we could look at that.
Let me ask a question, make sure I understand what you're saying. Are you saying any fictitious name would be misleading just because it's fictitious?
No, but I think there's some, like I said, because this was such an unusual thing. As I said, it could have been floppy or happy, or, I mean, we could come up with his point was to stand out. It was a marketing ploy. It is a marketing ploy. And I think that's where we start opening the gate of, is it professional? Are we representing our professional, who we are, when we start saying that anything's okay? And I think that's a question we have to consider. We have not had a very unusual, bizarre names before us in the past. But at this time, we had two that were really stood out as what's their point? And I don't think that's going to be the end of it.
If the feeling is that the committee doesn't need to explore this any further, we've already voted on it once, I'll be glad to withdraw my motion with the permission of the second.
So, I guess my personal preference would be that you maybe amend your motion.
Casey?
Mike?
To amend your motion to do what Mr. Alexander has suggested, that is, send this back to the licensing committee to address with regard to Mr. Crutchfield's application and solely with regard to that
And
issue.
that's fine. I adjust my motion accordingly.
Second the motion.
Okay.
Second that motion.
Now then, we're, any further discussion on the motion at this point?
It seems like that with that motion that's being considered, maybe I can understand Mr. Alexander's request to narrow it down to this one particular request, but I think Ms. Spiceland's argument that it's really a much, much bigger issue and we need to address the whole thing is the route that we really ought to take.
And I will say that by pushing it back down to the committee, recognizing that I'm on that committee, we're going to be right back where we were.
And could I just say real quick, I understand that we can't have a name that's misleading. It sounds like I'm hearing we don't like bizarre, unusual names, but not that that name is misleading. I still have not heard any sort of.
I think my thought when I heard the name, and I hadn't said a lot during this debate here. If I see a name, and I go by what I see first, I don't know what they do. And if I have a name of a company and somebody has to call me to ask me what kind of work I do, then my name is probably misleading. That's how, I'm just telling you that's how. It's not that it's a terrible name or
Well, he
or
had
anything like
offered
that.
to attach accountants
Right,
attached to it.
I'm just
though.
telling you, that was my first thought when I saw the name. I understand, if you add CPA to it, that kind of alleviates a lot of the problem. But I was just telling you, at first, when it came, when I saw the list of names, if to me, if without the CPA, in other words, if I have a name and people have to ask me, what kind of work do you do? And they're looking at my name, then that would be misleading. That's where I know you put the CPA and all that out there, but I know you keep asking why. So my initial thought, that's what it was. So, and that makes sense to me. If I look at the name of your company and I go, what in the world do you do? And you can't, and we're a CPA profession, then that, I'm just saying that's maybe where it originated a little bit from.
I respect that. Yes, sir. Is there any reason then to deny it if I go ahead and attach something to it that explains what it is that we do? If the problem is it's vague, because at that point,
I would be more apt to accept it. I'll say that much.
Okay.
Because at least I know you're a CPA. You're putting yourself out as a CPA. So when I see it, I know, okay, now the name, personally, I'd rather have Crutchfield because it's your company. And personally, I think you get more work if you put your name on there because most folks respect that. That's how I view it. All right, who am I sending my work to? Mr. Crutchfield. I would send my taxes or call somebody to do my tax work if it said Crutchfield CPA because that's you. But if I see a name that just says intra-account or inter-account and I don't know what they do initially, I'm not sending my tax work over there. I'm just telling you my opinion. And so that's why the name, in my mind, I would rather have, I want my name, if I'm a sole practitioner, I want my name on there.
And just a reminder that at both the motion phase now and if there's a referral to the October meeting, each member is, of course, free to vote his or her conscience and judgment on the motion and the eventual debate on the larger issue, and whatever happens or doesn't with Mr. Crutchfield's request. So, doesn't have to be unanimous all the way around. It's majority, quorum, and all that. So just putting that out there. So I believe we have a motion on the floor and a second at this time. And
I was going to make a suggestion, if we could go ahead and vote on that motion, would it be appropriate to have then a second motion to do with the broader issue of this whole thing? And I guess that's what I was asking a while ago. Should the Rules Committee be the one that really, kind of commission them or suggest they study this whole issue? Because it is a broader issue. It's more than just Mr. Crutchfield. It's a number of others. What do you do with the people that have already had their names approved versus what's going to happen going forward? And so, could we go ahead and vote on this motion and then we'll entertain another?
Turn it to the License Committee or the Rules Committee?
To the second one, to the
Crutchfield
Rules
is the
Committee. I think this motion is to refer this specific instance back to the License Committee.
But the bigger issue to the Rules Committee?
Yeah, because that would involve a rules change.
Thanks, Casey.
Okay. Okay? Boy, you're going to be chairman here soon, huh? Okay, we've got a motion and a second. Any further discussion? Hearing none. All in favor, say aye.
Aye.
Any opposed? Okay, now on the broader issue, while we're talking about this, does someone want to make a motion or suggest that we refer the broader issue to the Rules Committee?
So move.
Second.
Okay, any discussion? We've got a motion and a second. Any further discussion on the motion? Mark, I assume you know what we're asking here and will help us do this?
Yes, sir.
Get it, okay.
Yes, sir. Got it.
All right, got a motion and a second. All in favor of the motion, say aye.
Aye.
Any opposed? Mr. Crutchfield, thank you for being here today, and someone will be in contact with you soon on where we go from here.
Thank you all.
Okay.
Thanks.
Okay, the last item on the agenda is the legislative review. Is that going to be, Mr. Whitaker, pretty quick, or do we need to?
And give him just 1 minute.
We need to take a 5-minute break, or?
5-minute break might be a good idea.
All right, let's do that. Break 5 minutes and come back. The day's getting along, and we'll try to get everybody out of here.
It was after the implementation is going to be December 15th, 2015. And that they still wrestling with that, but that's what it looks like. The other thing that I forgot that is very important is that this gentleman right here serves as liaison for the executive directors on the NASBA Board of Directors this year. And Mark has been a participant and expressed his opinion, and as you all know, he can. But he's been a fantastic board member. He's represented the EDs well, but he's also represented the state board very well.
Okay. Thank you, and thank you, Mark. So, at this point, I think we've got one more item on the formal agenda, and that's the legislative review from Mr. Whitaker.
thank you, Mr. Stewart, and I'm sure you'll all be pleased to know joyously that this is the shortest item on the whole agenda by a lot. There were no statutes that were passed in the last legislative session that ended in May that were specifically applicable to the Board of Accountancy only. There were 3 that were passed relative to the Regulatory Board's division under which the Accountancy Board is attached. Mark referenced one of them earlier. I don't have the public chapter site in front of me, but it was about the 90-day professional privilege tax matter, where if somebody is 90 days delinquent and then after that 90 days attempts to apply for their license to be renewed, they're not supposed to be able to do it, or it's somehow technologically, magically speaking, and I'm not an IT person, but or is supposed to not be allowed to happen. That is, as I understand it, in the works, and how to actually make that happen, but I don't really think there's anything Mark or I can do or should do to, on the technology end of things. It'll just be up to mostly Mark and the staff to work with revenue when necessary, and the Reg Board's division when necessary, on implementing the requirements of that particular public chapter. The second one is public chapter number 815. It's an amendment regarding something called a certificate of employability, and basically this is not going to apply very often to CPAs, but it might. And the statutory amendment is under Title 40, and part of that handles things like pardons, paroles, commutation, things like that. And if someone has previously been a convicted felon and rendered infamous, meaning that they don't have their citizenship rights like voting and the like, this public chapter creates something called a certificate of employability that person can apply for from a court, and if they are granted it, then they are supposed to be essentially presumed to be employable. And the thing that you all need to know is that on the surface it appears to preempt board rules that state that somebody who has been a convicted felon can be denied on that basis only. Now, if they were a convicted felon and also had other stuff, then you could still deny them for the other stuff. But the public chapter also contains a provision which I will read to you. It says, notwithstanding these pieces of this statute, a board, agency, or commission or other licensing entity may adopt a rule on or after the effective date of this act, denying the issuance, restoration, or renewal of a license or certificate to a person, notwithstanding the possession of a certificate of employability based on the time that has elapsed since the criminal offense, or B, the nature of the offense having a direct bearing on the fitness or ability of the person to perform one or more duties or responsibilities related to the license or certificate sought. That is fancy lawyer language for, if you guys adopt a rule that says we can deny it notwithstanding a certificate of employability because not enough time has passed since they committed the crimes they committed, or that, for example, they were convicted of embezzlement, stealing client funds, something like that, that has a direct bearing on the CPA profession. As long as you have that rule in place, even if they come waving that certificate in here, you can still deny them. So that is something that will most likely be the subject of a future rule change, which will require a new trip into the hopper. So may well be looking at a presentation on that to the Law and Rules Committee in October. And if that's the case, then I will work to come up with some language that will probably mirror pretty closely what I just read you. And last but not least, we have Public Chapter 881. This was a statute passed requiring all regulatory programs in consultation with the Division of Reg Boards to develop a plan to create an apprentice program for use by such boards and commissions. Notice this says create a plan, not create a program. And so each program under Reg Boards has to submit their response to this report no later than December 31st of this year. So there are some factors listed that the board is going to need to consider. Mark and I will be coming up with something on these 6 items, but I will probably have Mark email you all a copy of this public chapter so that you have these factors to think about. And they are: the plan developed pursuant to this section shall include the subjects of apprenticeship training, supervisory standards, occupational instruction, wages and benefits, licensure, and the role of the Division of Reg Boards in implementing the program. The good news for you guys is you've already got a 1-year experience requirement in place that has to be complied with prior to licensure anyway, and that may well satisfy it. And if that's the determination, then really it will be a recitation on behalf of this program of what's already in place, of the stuff that we can respond to and the stuff that we can't, say, we don't really know what to do with this. But again, Mark and I will be working on this, and I will ask Mark to email you this public chapter. So if any board member has thoughts about any of these 5 or 6 items here that you would like to share with Mark or I, please do so individually. Don't email each other, open meetings and all that. But please feel free to send that back to us so that it can be incorporated, if necessary, and discussed in October, because October will be you guys' last board meeting before that December 31st, 2014 deadline for the report to be submitted on behalf of the Division of Reg Boards. So we will have to have you guys vote on a response to this for approval in October, and then we send it along with every other program, and then that will be in the report, and it'll go to all the people that are listed in the statute, and what they do with it from there, who knows. So that concludes my legislative review. If anyone has questions, I'll take them. If not, that's it.
Any questions on the legislative report? Okay, that's all the agenda items that I have. Is there anything else anybody wants to bring up at this point? If not, I'll entertain a motion that we adjourn. All in favor say aye. Aye. Good.
Good weekend, Steve.
Thank you. I'm not sure.